offense is 376. That is the charge sheet. But the statement also makes out a case of attempt.
Yeah, they've settled. Why should we
They have
go into all this thing? Yes. I'll take it up immediately. After mentioning?
Yes.
Yes, yes. Yes.
Item 1 to 7. At page 2, item 8 to 22.
My lord, item 19, my lord. Then after vacation.
After
My lord, item 12 after vacation.
19. Oblige, my lord.
Page 3, item 23 to 34.
34, my lord, question of proceeding on the ground of compromise. Parties are common.
12 o'clock.
Yes.
Page 4, item 35 to 48. Page 5, item 49 to 62. Page 6, item 63 to 77. Page 7, item 78 to 87. Page 8, item 88 to 97.
89, my lord. Taken up after vacation. 89.
95, my lord.
After vacation, in order to continue. 89.
Three-quarter will continue.
95, my lord.
Yes.
Item number 95 after vacation.
Yes.
95.
Page 9, item 98 to 106.
Lordship, item 103. The IA was for hearing today. Your Lordship, I pray do not press the IA.
Not pressing. I not pressed. I not pressed. Yes.
Page 10, item 107 to 113.
111, my lord. It's a hearing matter. It will take time. My lord, senior is there.
It was
Let it
adjourned
happen.
to the 17th. Since it was not listed, I had got it listed. So since this is the last day, I will not object to it. But may I pray, let it be listed on 20th of June.
20th June.
20th have some difficulty. 21st also.
Let it be listed. 21st.
21st. And at 3 o'clock.
Aye.
If hearing takes place, then
Aye.
3 o'clock.
Page 11, item 114 to 122.
Item 115, let it come after vacation.
Yes. No.
Item 2 will be taken first one as before.
Item 1 for the other.
Item 1.
Item 2 I'll take just after one. Item.
Please, your lordship.
Yes. Who is the informant?
Informant is dead, my lords. The victim I have included as OP3. She is
Hey, who is 2 and 3?
2 is the informant.
He died.
He is dead.
Okay. Okay. Right.
3 is the victim.
Where is Rasmi Ranjan Bera?
I am appearing on behalf of OP number 3 and I have
Rashmi Behra is there.
his number.
And Mamata Mohan.
Condition may consider this. The word is not there. The line is not.
That is not the order.
No. I have said that.
My lord has
I
said
have
that.
recorded your statement.
No,
And
no,
I
my
said
lord.
that you move a phrase application.
No, my lord has said that instead of
Show me the order.
yes,
Show me the order. If you have.
Oh, it is.
Show me the order. What
What
happened?
government surety
Had you moved the application?
today I am already
Remove the
instructed there.
application. Why are you
But because even though they are not order, again same order will come. That today is the last working day. No other option is there.
No, para 3 just read. Mr. Padi, counsel for the petition.
Yes. But observation of my lord.
has been that there is no government servant available.
No, my lord. That is observation there. But finally, my lord said that I am passing an order saying that the government surety is not a bar for taking consideration of this. That was not there.
We have objected that yesterday because my lord, that is not the.
You objected everything.
See, that is the reason I passed a balanced order.
My lord.
And I think sufficient
My lord,
indication.
my lord, that's why.
I'll tell you, sufficient indication is given to the trial court, you will understand.
My lord.
If it doesn't happen, come and mention at 2 o'clock. I'm here. I think,
That's why
I
the
think a
Calcutta High
judicial
Court.
I think a judicial officer will understand what is the.
No, this is not a judicial officer. This whole problem is this. He's a bureaucrat and he will not have understanding.
Let us see.
Paragraph 5 can see.
Then I'll take. Right.
Paragraph
Don't take that much over-interested.
No, it's all right.
Take it sportively.
All right.
Paragraph 5 can
It
see.
appears to be a political.
Some correction is required, my lord. Paragraph 5, my lord. Last sentence. STJM ହେଇଯାଇଛି. STM ହବା କଥା.
ST.
SDM.
STJM ହେଇଯାଇଛି. ଶୁଭ.
ସେଟା ଜେନେରାଲ ପ୍ରାକ୍ଟିସ ରୁ ହୁଏ ଆଉ କାଣା ଏଟା ଗୋଟେ ଏକ୍ସେପସନ ହେଇଛି
ଅପଲୋଡ ଟାକୁ ଆଉ କରିବି.
SDM ହବ
SDM ହବ.
ସବ ଡିଭିଜନାଲ ମାଜିଷ୍ଟ୍ରେଟ
ପୁରା 5 ରେ.
5 ରେ.
STJM ନା.
JM ହବନି M କହ
ଜୁଡିସିଆଲ ଅଫିସର ଆସିବ.
ଏଟା ହଉଛି SDM
A ହବ କଥା।
ସବ କଲେକ୍ଟର ୟେସ୍
STM
ଖାଲି M ଯେଟା ଉଠି
ଯେଟା ଜୁଡିସିଆଲ ରହିବନି ଏଇଠି ଯୋଉ ଯେ ଅଛି ନା ଏଇଟାକୁ କାଟିଦବ କାଟି ଦେଇକିରି
ଆଉ ଥରେ ଅପଲୋଡ କରିଦେବେ।
ଟିକେ କହିଦେବ ଏଇଟା କାଟିକିରି କରିଦବ and you see I think sufficient indication is given.
No, I've seen that. I've seen that. But ultimately, the final observation, the court will be taken care of.
No,
That's why I'm telling.
this much indication is enough.
Let us see.
Hey,
what
you
is
take
again.
care.
देखिए,
Yes.
ऊपर की बात.
Item
My lord. My lord, both are working there in this surround affidavit.
Yeah.
And they have settled it.
There-
After the copy,
Now you have taken the suit. What, madam? You have any grievance?
Here, my lord, someone issued, they did not appear for that.
I see, acha. The, someone to appear before court, however, he did not appear, in the court leading to, issuance of NBW on 6/7.
7/23 already.
23, that is a 500, yes.
51.
That's order of NBW 22/6/2020. And annexure one is the bail order and annexure to the order of NBW.
Bail on 24/12/2018, NBW 22/6/2022, 500, yes.
52.
52.
मिलर बेल ऑर्डर डेटेड 2/1/2019 बेल ऑर्डर NBW issued
NBW 24/2/2023.
5/11/2022 and 24/2/2023.
Last one, that is matched with the subsequent one.
During course of investigation, they are bail, my lord. After submission, someone issued, that did not appear.
No, charge sheet file.
Charge sheet for
It's
someone.
all right, all right. Someone, bail, chalo.
53.
53.
Next, NBW.
Petitioner is an accused in ICC case under section 130 NIA due to absence in the court on 15/11/2023. NBW was issued. Cancel.
54.
Complaint case is no cost.
Belgium permitted to submit on behalf of Mr.
Yes,
Mahapatra.
tell me.
NBW was issued on 25/7/2023. He was bail on 21 December 2017.
500. Yes.
55.
500 each. There are two petitioners, 500 each.
Yes, ma'am.
Yes.
I plead you, Lordship.
55.
55.
Yes.
55. Lordship, warrant has been issued against the present petitioners. Lordship, it's a foreign warrant. Lordship, your Lordship, you well aware about the subsection 2 of section 78.
So forget, you tell me when you are in the way.
No, my lord. What happened is warrant issued by the Calcutta court.
Calcutta Court. Metropolitan Magistrate.
He is submitting before filing the, my lord, only the, without filing the warrant or order, my lord. Only the warrant, my lord, warrant he has filed one.
Warrant.
This month.
That
And
is not available.
their submission, my lord. That foreign
Substance
warrant.
of allegation must be there. This is the law.
It is appropriate.
But it has not been mentioned. It's a defective warrant.
How can I?
Appropriate to
Lordship,
move before
that
the Calcutta High Court, my lord.
You know,
Here, what happened in this case, my lord? Both the cases in Odisha, my lord. For one police station and another police station. For that reason, they have arrested in one police station and taken to the custody and an interval granted to him to appear the appropriate court, my lord. They did not appear. For that, NBW issued, and that case the honorable court quashed, my lord.
Then it's a defective
So, but
warrant.
both case in within the jurisdiction of Odisha, my lord.
No,
Here,
talk
my lord,
about this case. Forget about what judgment will do.
Yes, Your Lordship.
Calcutta court has issued a warrant and you withdraw it and
Approach it.
nobody is going to arrest you here. I can't protect you because Calcutta High Court.
Lordship,
how can
what
I
has
do that?
happened? IIC Ersama police station is directed to arrest me.
Antecedent, my lord.
Lordship, here may Your Lordship may see.
Where is that?
I have given the orders.
Where? You have not filed anything.
Your Lordship.
See, order tell and the
Later on, I will get it and file already filed.
Where is that?
That must be annexed to Your Lordship.
if, my lord, in this type of cases, my lord, if he'll be arrested in the asylum basis, he will taken to the, my lord, executive magistrate and transit to
Transit bail you will get it.
সেটা হয়ে পারে সেটা unless arrested, how can court quash
IIC Ersama police station is directed, Your Lordship.
হ্যাঁ ହେଲେ ସେଠି ଗଲେ ସେ ଏକ୍ଜିକ୍ୟୁଟିଭ ମ୍ୟାଜିଷ୍ଟ୍ରେଟ୍ ପ୍ରଡ୍ୟୁସ କରିବେ, ଏକ୍ଜିକ୍ୟୁଟିଭ ମ୍ୟାଜିଷ୍ଟ୍ରେଟ୍ ଟ୍ରାନଜିଟ୍ ବେଲ୍ ଯିବେ ଆପଣ।
ଟ୍ରାନଜିଟ୍ ବେଲ୍ କରିବ କଣ ଟ୍ରାନଜିଟ୍ ବେଲ୍ ତ ମିଳିବ
Your
406, 420, 120.
Lordship may protect me and Your Lordship may fix up a date so that I will appear and Your
Petitioner
Lordship's usual order is
petitioner submits that in pursuant to the warrant issued by which court is this?
Metropolitan Magistrate, Calcutta, 13th Court for Calcutta.
What?
Metropolitan Magistrate,
Huh.
13th Court, Calcutta.
13 court, Calcutta. The who is the IIC?
IAC Ersama Police Station is directed.
IIC Ersama Police. Ersana. Huh? Where is that?
Ersama Police Station.
Ersama Police. Acha, Ersama Police. IIC Ersama Police is
Direct to arrest the
is seeking the presence of the petitioner to arrest arrest him and produce before the
Nearest magistrate.
jurisdictional court. Produce before
Jurisdictional.
jurisdictional court.
Maybe CJ, maybe
Jurisdictional court. Let us count what the petitioner submits that he would appear before the jurisdictional court is what?
either CGM or my lord the executive magistrate.
Appear before the IIC Ersema. On or before?
Your Lordship fix up that.
On or before June, 15th June. On or before 15th June, and if the petitioner appears before him, he shall be produced before the jurisdictional court, and appropriate order in regard to the transit bail.
Nearest jurisdictional magistrate.
Nearest judicial
भागो Calcutta से
jurisdictional court of the police station, of the same police station. And if police station, if he appears before the before the court of jurisdictional court, his transit bail application shall be considered on its own merits.
If application move, if such application move,
If such application,
Yes. Till then,
till then no court. तो 31st June कर दिया ना, 31st June, ठीक, चलो. And ideally, you should go and tell the police. Police will take you and move transit bail there, and then you get it.
Lordships have given the date on or before.
on or before.
Yes.
56.
Yes.
हम तो ଦେଇନାହାନ୍ତି ଆମ କପିରେ ଦେଇନାହାନ୍ତି ୱାରେଣ୍ଟ କେବଳ ଖାଲି ଗୋଟେ ପେଜ ଦେଇଛନ୍ତି ଆନେକ୍ସ 2 ପେଜ 18
NBW issued.
ଏଇଟା ଆମ ଦେଇନାହାନ୍ତି. Your Lordship, if they file my lord with Your Lordship, file not with us, my lord. Only one page, my lord. That is court title.
No supervision taken.
Annex 2. केवल court title देता हूँ.
कुछ लिखते नहीं ना, that's the problem. देखो, the petitioner was
Page 19
large on bail,
19
large on bail by this court by order dated 9/4/2012 in a PLAPL number 8328 of 2012. However, due to his absence in the court by order dated 12/11/2012, NBW was issued. ठीक है, पास कर दियो 1000. ठीक है.
57.
छोड़ो ना, उन्होंने पीएस किया
57.
फिर आके एप्लीकेशन लगाया क्या फायदा. हाँ 57 yes.
CS showing absconder and NBW issue.
You was shown as absconder.
Or no?
The petitioner was absconder. IIC कोई on the who's
no charge sheet showing absent there after NBW.
The petitioner was
But page the accused person is absconded. In this case, issue NBW against accused Kumar Mahanta Kiran.
Petitioner was absconding. Therefore, the court has issued the NBW by order dated.
My lord, order dated 8 to
8 by, yeah,
23.
8 by 23. GR case in here.
And NBW may state and a time given to appear.
500, huh? Next.
58. 58.
58.
My lord. Release on bail on 11, 17, 11, 17 and NBW 3, 4, 24.
The petitioner was released on bail on 17/11/2017. And subsequently, charge sheet was submitted on 12/1/2018 due to the absence. The court below had issued NBW on 3/4/2024. Okay. 500. Yes.
59.
NBW 11/10/2022. Petitioner released on bail on 19/17/2021.
500.
60. 60 my lord, NBW release on ABLAPL 4/14 and NBW 1/8/2016.
Date
1/8/2016.
ABPL number, petitioner was granted anticipatory bail on 4/9/2014 in ABPL number 16089 of 2014. However, due to absence, NBW issued on
Order
2016.
Order shows that perusal the same. It reveals that the accused received the summons by himself. Hence, the report to be sufficient. Issue NBW.
ठीक है एक 8 छोड़ो 1000
61
61 रे बेल होची 13/7/2017 किंतु नो NBW
चलो
the order itself shows that NBW since long it was issued, but this 11/5/2018 page 9 you'll also may kindly see NBW issued against the concerned Hemant Das has not yet been executed. So this is not the date of NBW.
but that is not executed, is continuing.
No, no,
But
earlier
नहीं say date ता दरकार नहीं NBW date ता कितना दरकी है
ठीक 11/5/2018
ना सेटा NBW ना जो NBW ला issue ही दिला
but it is
आप
not
तो खाली mention कर दे बजे
NBW was not executed.
हाँ सेटा खाली कर दियो तो
Now, where is that order? Where is it?
page 9
9.
order dated 11/5/2018
All the accused persons are absent from, so no step has been taken by local bar association. NBW issued against the accused so has not yet been executed.
तेणु से जो NBW को तारीख रे इश्यू हितला सेटा नहीं
The petitioner has essayed the order dated 11/5/2018, whereby the court below inter alia has stated that that the NBW issued against the petitioner earlier has not been executed yet.
right
Yet. The petitioner doesn't disclose on which date the NBW has been issued.
yes
Has been issued. Be that as it may, the NBW issued, be that as it may, the impugn order dated 11/5/2018 is the execution of NBW, execution of the order dated 11/5/2018 shall remain stayed till 30th of June so subject to petitioner so appearing.
Yes.
Appearing and seeking remedy.
bail date will also be indicated bail date
He was
bail
he was on bail.
13/7/2017
Petitioner was on bail. Petitioner was on bail on 13
7/2017
ठीक. Next.
62
Ma'am, please alert. मतलब NBW has been issued on 18th July 2022, man. 18th July.
Bail.
He was directed to be released on bail on 25th February 2020.
22
25/2/20 bail author's সাথ vice NBW.
500. Yes.
63. In December 2023.
Yes.
Petition religion bill 14/12/2015.
500.
Obligation.
64.
Well, bail was granted on 10/1/2022 and NBW granted 7/11/2023.
500.
65.
65. NBW 5/9/2023. Only he has written he was on bail.
5/9 or 25/9?
5/9.
25/9. 25/9 लिखा है. 25/9 sir. Accused is absent. No steps is taken on behalf of the accused person.
মতে যে সার্টিফিকেট কপি দিলেন
LPW.
মতে যে সার্টিফিকেট কপি দিলেন লেখা আছে 5/9/2000
No, that দুইটা উড়ে গেছে. আরাম আরাম.
65
25 না তো 25 না NBW 25 না.
Lord, sir.
25 না
বেল কে বেল
he was on bail no date.
नो डेट. चलो 500.
ମୁଁ ପାସ
ठीक है ठीक है पास और कौन 5/9.
ওভার করছো না
66.
66, my lord. NBW resolution 5/2/24 in execution case note 74/23.
এটা ডিবি প্রসিডিং রে মেইনটেন্যান্স ডাইরেকশন দিয়েছিল পেমেন্ট করে পাই he has not paid. That is why NBW issued. First DW, then not compliant, then NBW.
Will appear in the execution case.
For non-compliance of the maintenance order.
Maintenance DB proceeding.
Maintenance order passed against the petitioner in a DB proceeding initiated by the opposite party. Opposite party by his wife. By
Yes,
his
yes.
wife.
Yes.
NBW has been issued on
5/2/24.
5/2/24. 5/2/24.
5/2/24.
Space 27. Space 27.
Right, subject to petitioner complying with the order of maintenance passed by the PV court and appearing before the court on or before 30th of June. The petitioner shall appear before the court below on or before so and seek remedy as available under.
67.
ಇದು ಬೆಲ್ಜಿಯಂটা ಸರ್ಜಿಯೋ ಬೆಲ್ಜಿಯಂ ಸರ್
Petitioner swear on bail, my lords, and NBW has issued, my lord, 28/2/2024.
Bail, you did tell me this.
Date or not there, my lords, but petitioner when
Petitioner swear on bail करो.
my lords,
28/2/2024.
my lords.
500.
68.
68 also petitioner swear on bail, my lord. NBW has issued 24/7/2023, my lords.
500.
69.
500 each. 3 জন আছেন.
My lords.
500 each. Yes.
69.
69 petitioner swear on bail, my lord. NBW has issued, my lord, 17/8/2023, my lords.
500.
One person, my lord, that's
Give 500. Yes.
70.
70, my lords, petitioner swear on bail, my lord. NBW has issued 26/11/2024, my lord. 24, my lord. 24, my lords.
Bail date you don't know.
Bail-
My lord, bail does-
no bail date.
चलो 500 each.
71.
71, my lords. NBW has issued, my lord, 24/1/2023. He was on bail, my lords.
500.
72.
May prejudice not. Belgium. NBW determined 7/8/23 granted anticipated bail by this honorable court, madam.
Huh?
Anticipated bail was granted.
Date. Give the date.
7/8/23 madam is NBW.
अरे anticipatory date.
9/7/21.
9/7/21. 9/7/21 in ABPL number 5361 of 2019. ठीक है. NBW 7/8/23. 500.
Oblige.
73.
May I please one? My lord, NBW issued an execution miscarriage in DB proceeding, your lordship. DW issued along with conditional NBW.
Right on.
Order dated
NBW
29/8/23.
NBW has been issued on
29/8/23.
2023 due to the failure on the part of the petitioner to comply in the maintenance order passed in a DB proceeding. Subject to petitioner appearing before the honor before such and such day and complying the order of the DB court, order passed in a DB proceeding. NBW issued on such and such day. Execution of NBW issued on such and such day. The petitioner is directed to appear on or before such and such day and avail remedy on the law. Yes. No,
Right.
workable.
74. Bill was granted on 4 for 24 million. NBW was issued on 8 for 24 million.
500.
75.
May I please ask?
Yes.
My lord, petitioner bailed on February 8, 2017 and NBW issued on September 5, 2022.
How many of you are there? 14 people.
15.
15 କେତେ ଟଙ୍କା ଦବ
15 people. All of you are on the bail. Huh?
Yes.
Voting and all. Then you pay 10,000? No, not 5,000. 5,000 in
Okay.
total.
76.
76, my lord, NBW issued on 19/10/22, my lord. But certified copy could not be obtained, my lord. File had been misplaced by the learned court below, for which I have filed an IA, my lord. 2008 file, my lord. I have applied the CA copy application. I have annexed
NBW issued.
19/10/22.
You tell me NBW is 19/10/22 and bail
10/8/2009.
10/8/2009. 500. Pay and go.
77.
My lord, bail was granted on 18/11/2020 and NBW issued on 1/3/2024.
24. 500. Yes.
78.
May I please ask? My 3/7 petition was rejected and NBW was issued on 13/5/2024, your lordship. The main accused have been protected by this honorable court by the order dated 16/5/2024.
When the bail was granted?
3/5/2024, your lord.
3/5/24.
Yes, your lord.
And NBW issued on
13/5/2024. My 3/7 petition was rejected and then NBW
Yes.
was
Okay, 500 each.
obliged, your lordship.
79.
NBW issued on 25/2/2020. Bail on 1/6/2013.
Huh?
NBW issued on 25
Give the bail date.
bail date 1/6/2013. 2013.
2013. Yes. 25/2/2020 is the NBW. Okay.
Yes, madam.
500.
80.
18 NBW issued on 26/4/2024. And bail on 19/12/2017.
19/12/2017. 500.
Problem.
81.
Madam, NBW issued 23/11/2023. Earlier he was on bail in 2/1/2019.
Got it?
Obliged.
82.
Lordship, I mean VC Lordship. NBW was issued on 10th of December 2021 and bail was granted on 28th of August 2018, my lord.
Got it? 500.
83.
My lord, bail was granted on 24/2/2020 and NBW was issued on 12/6/2023.
21.
23.
500.
84.
My lord, bail was granted on 10/2/2023 and NBW issued on 11/4/2024.
500.
Obliged.
I maybe pardon make a mention, my lord. Item number 221, compromise matter, and there the Honorable Court of my lord Justice Sinha and my lord Justice Sahu, my lord, yesterday directed me to make a mention. Accordingly, I made a mention and it has been listed. And the matter in a matter, the matter has been compromised. 15 lakhs has been awarded, given as the permanent alimony, and both the parties are there. My lord, and my lord has kept
Take
it.
it 12 o'clock.
They have kept it fast case, my lord, to be mentioned.
Where?
in the my lord before Justice Kum, my lord. Court
Do
number
will
1.
come, I'll do, take it at 2 o'clock or
12, my lord, because they, my
12
lord,
o'clock, okay, I'll take it 12 o'clock. Go and do that matter first.
no, there my lord has kept it only after disposal, my lord has said, that's why, if it can be taken up now, my lord, it can be.
No, I didn't follow. That Mata case has nothing to do with this.
No. My lord has, because of the fact that the amount has already drafted to 2 drafts, 10 lakhs and 5 lakhs has already been deposited before the concerned court. Only after disposal of this case, only the money will be released in favor of the wife, my lord.
There are like 12.
Sorry, guys, sir,
21 they are waiting for this proceeding to.
Much obliged. Offense 498A.
1 minute. 498.
Offense 498A, my lord, and
It is a contested.
and at the second, my lord, good sense people between the parties and
Well, I'm
Who
for
are
the
the
OP
parties?
wife. lords.
Who are the parties?
petition number 1 is the husband. Other 3 are not before the son of court, who are the father-in-law, father-in-law, sister-in-law, and brother-in-law. Only petition number 1, who is the husband, is present before my lord. And so far, wife, opposite party number 2, she is also present before the son of court, my lord. And offense 498A, 494, 406, 506.
Mr. Maharaj. Problem होती ना. What happened the other day? Accused were not there. We passed the order. Thereafter, he says that he was in custody.
No. In such a case, the opposite party number 2, opposite party number 3, my lord, he is serving as a constable, Habildar.
I'll record his statement.
My lord, my record my statement.
I'll record his statement. Right out. At the instance of opposite party number 2, FIR number so and so came to be registered against the petitioner. After charge sheet was filed by the police by the order dated 3/3/2020, cognizance of offense under section 498A, 40 what is this? 406, 506, 34 read with section 4 of the DP Act has been taken against all the petitioners. The petitioner, the parties have settled their dispute. Who had filed this divorce petition? Husband.
Pardon?
Who had filed the divorce petition?
Divorce petition husband filed.
The husband filed a divorce petition. Divorce petition under section 13 of NIA. HMA.
Hindu Marriage Act.
What was the order?
15 to be paid with 15 lakhs along with the gold ornaments and
divorce was granted.
Divorce was granted subject to payment.
Filed the matter.
No, divorce was granted subject to payment of 15 lakhs as permanent alimony. Against that, I up to the Honorable Court. And in matter number.
Right down. These matters are very delicate, you know. Matrimonial, high emotions, and you never know what happens. Yes, sir.
My pleasure. Here in this case, my lord, the affair was lodged when an accident was occurred in front of the police station, my lord. Affair was lodged by the police, stating that one Nolini Kanto Panigra.
Use mic.
Hello?
Mic.
Yes. Affair lodged by the police, my lord, against one Nolini Kanto Panigrahi after an accident occurred in front of the police station, my lord. And several persons have gathered there. There is a, my lord, some persons have entered inside the police station and they destroyed some records. This is the allegation, my lord. And affair is lodged against one Nolini Panigrahi and 50 to 60 others, my lord. Subsequently, my lord.
You are one among them.
No, I have Kahanar Charshi Delan. Nolini Kanta, he has expired. And affair lodged charge sheet submitted against me, my lord, under section 149, 147 and other offences, my lord. For which your lordship has directed me to file the charge sheet copy. I have also filed, my lord. So 149 lordships.
What are the allegations you tell me?
Allegation I am monarch is more rather your lordship. I am placing one statement of Sushant Kumar Das, my lord. He has stated that muda buja buji korthili jaoni simba Hon'Ble koroni. In spite of that, I have been arraigned and accused.
No, come to para 16 of the charge sheet.
My lord.
Prima facie evidence as so against the accused person Seni Dilip Kumar Das. You are the main accused.
Main accused kin
Charge sheet submitted to him asked under.
Nolini Kanta maan jayega no pa main accused hai affair hai.
Here, my lord.
The lordship may kindly see the affair. FIR against
Forget about the FIR.
160
After investigation.
ବର୍ତ୍ତମାନ ସିଏ ଯେମିତି ମରିଗଲା ଆଜ୍ଞା ମତେ ମାନେ
ଚାର୍ଜସିଟ୍
ଆଉ ଗୋଟେ ଷ୍ଟେଟମେଣ୍ଟ ଆଜ୍ଞା ଦେଖନ୍ତୁ ମୁଁ କେମିତି ମେନ୍ ଆକ୍ୟୁଜ ହେଲି ମୁଁ ଯଦି ବୁଝଉଥିଲି ହାଉ କ୍ୟାନ୍ ଆଇ ମେନ୍ ଆକ୍ୟୁଜ
ହେମାମଣି ନାୟକ evidence ପଢ
ମାଇଲ ଜେମାମଣି ହେମାମଣି ନାୟକ ଉପସ୍ଥିତ ମୋର ମୌଖିକ ବୟାନ ଦେଉଛି ଯେ ନାୟକ ରାତିରେ ଡ୍ୟୁଟି କରିବା ପାଇଁ ଯାଇଥିଲେ ଉକ୍ତ ଦିନ ସକାଳେ ମୋର ସମୟରେ ଥାନାରୁ ଆମେ ଖବର ପାଇଲୁ ଯେ ଆମର ପୁଅର ଦୁର୍ଘଟଣା ଘଟିଅଛି ଓ ସେ ମୃତ୍ୟୁବରଣ କରିଯାଇଛି ଆମ୍ଭ ପୁତ୍ରର ମୃତ୍ୟୁ ଖବର ପାଇବା ମାତ୍ରେ ଆମ୍ଭେ ମାନସିକ ଭାରସାମ୍ୟ ହରାଇ ବସିଥିଲୁ ତହିଁ ପରଦିନ ଯଥା ସ୍ୱୟଂ ସମୟରେ ଖନ୍ତାପଡ଼ା ଥାନାରୁ ସାର୍ ଡକାଇ ପଠାଇବାରୁ ଆମେ ଆମର ପରିବାର ଲୋକଙ୍କ ସହିତ ଯାଇ ଖନ୍ତାପଡ଼ା ଥାନାରେ ଯାଇ ସାରଙ୍କ ନିକଟରେ ଉପସ୍ଥିତ ହୋଇଥିଲୁ ଖନ୍ତାପଡ଼ା ଥାନାରେ ସାରଙ୍କ ସହ ସାକ୍ଷାତ କରି ସାରିବା ପରେ ଆମ୍ଭେ
ଇଏ କିଛି କହିନି
ନାଇଁ ଏ ସୁଶାନ୍ତ ଆଜ୍ଞା କହି ଟିକେ ତାପରେ
ସରସ୍ୱତୀ
ସେମ୍ ମାଇଲଡ ତାପରେ ସେ 4 ର ଅଛି ସୁଶାନ୍ତ 5 ର ଅଛି ଆଜ୍ଞା ଆଉ 2ଟା ପରେ ଏଇଠି ମୋ ନାଁଟାକୁ ଏଣ୍ଟ୍ରି କରେଇଲେ ପୁଲିସ
ଦିଲ୍ଲୀପ ଦାସ
ହଁ ଦିଲ୍ଲୀପ ବିଶାଳ ଭାଷାରେ ଗାଳି ଗୁଲଜ କରୁଥିବା ସେଇ ସମୟରେ ସ୍ଥାନୀୟ ନଳିନୀ ପାଣିଗ୍ରାହୀ ଓ ସନି ଓରଫ ଦିଲ୍ଲୀପ ଦାସ ସେଠାରେ ପହଞ୍ଚି ବୁଝାସୁଝା କରୁଥିବା ବେଳେ କିଛି ଲୋକ ଥାନା ଭିତରୁ ପଶିଗଲେ
ଆଉ ପୋଲିସ କରିବା ସମୟରେ
ପୋଲିସ
ବିଭିନ୍ନ ପ୍ରକାର ଭଙ୍ଗାରୁଜା କଲେ
ସେଇ ତ ଏଲିଗେସନ ଭଙ୍ଗାରୁଜା ସେମାନେ କଲେ ଆମେ ବୁଝାବୁଝି କରୁଥିଲେ ଲାଷ୍ଟ ଡେ ଅଫ ଦି ଭେକେସନ
ବଟ ଚାର୍ଜସିଟ୍ ସବମିଟେଡ ଶୋଇଂ ହିମ୍ ଆଜ୍ abscond ନାଇଁ
ନାଇଁ ସେଟା ମୁଁ ଆଇ ହାଭ ଅଲରେଡି
ଆଉ ଗୋଟେ ଅଛି ଆଉ
got the bill
ମାଇଲଡ
got the bill
ନା
ହଁ ଆଇ ଗଟ୍
got the bill
raise the point before the at the time of framing charge
CD
140 offense ନା offense ଉଡା
ନା ଆପଣଙ୍କ ନାଁ ଅଛି ନା ଆଉ ଜଣେ
ଭାଇ ଛୁଟି ଆଗ ଛୁଟି ଦିନ
issue notice get the CD କିଛି ନାହିଁ yes
ଏଣ୍ଟ୍ରି ମଡେଲ
what entry model
এটা নহলে প্রসিড কৰি দিব কেস
କିଛି ହବନି
ମୁଁ ସରେଣ୍ଡର କରି গলেনি
cognizance ନେଇଛନ୍ତି
ମୁଁ ସରେଣ୍ଡର କରି ବେল ହେଇ গলেনি
no
ଆପଣ ରିଓପନିଂ ଟା
problem is there are many accused one
charge submitted only one ballot that's it only final charge sheet this is final charge sheet
charge sheet against you only
56% I am only the accused well take lots of can be
then you move application
after vacation at least after vacation
discharge file करते
नहीं after vacation पर्यंत थाउ स्टेट
discharge कर दो
lots of fixed date on that day till then I may
why are you not filing discharge
आगे here again he will come and again he will come to the court यदि आप it is negated if I will apply your lordships by citing from distance then maybe fulfill my purpose my lord because there are several persons have been arrested if there is my lord I
what are the
Sony
must be there
दिलीप दासଙ୍କ ସହିତ ତାଙ୍କ ସମର୍ଥକ ମାନେ ଥାନା ସାମ୍ନାରେ ସକାଳ ପ୍ରାୟ 6:30 ସମୟରେ ହାଜର ହୋଇ ଆମକୁ ଅଶ୍ଳୀଳ ଭାଷାରେ ଗାଳି ଗୁଲଜ କରି ଧମକ ଚମକ ଦେଲେ ଓ ଫୋନ କଲେ ଲୋକମାନେ ଓ ଡକାଇଲେ ଧରାଧରି ବହୁତ ଲୋକ ଏଟା ହଉଛି ୱିଟନେସ୍ ବିକ୍ରମ କୁମାର ମହାପାତ୍ର
ଯଦି ମୁଁ ଡକେଇଲି ସେମାନେ କାହାନ୍ତି
ଆଲିଗେସନ
who are they
those things are not relevant
ଅଛି
one thing I am giving you liberty to move application for
I will cite some decisions my lord
what decision on facts you have some allegation
well, I know my lord because when there is
for the petitioner seeks to withdraw this petition to application before the court below seeking discharge from the case as no case is made out against him as per the charges. If such application is moved, the same shall be considered on its merit. Till the application is till the said application is disposed of by the court below, no court switch. But I have said no court switch. You for professional purposes,
no purpose will solve after vacation I guess. So simply your lordships make it
by that time.
Can't coerce evidence ଅଛି
कोन एविडेंस अछि 70% आसले when there is a big chance of conviction so decision thibo cognizance should be quashed
better that you go there
after vacation I am not praying my lord losses simply arjun to after because छुट्टी आगो दिन आगे टिके हुए नि छुट्टी दिनटा नॉर्मलिटी के लॉस सर
हां तो नॉर्मल
consider my lord
simply example
after data fixing
but it would have been better you would have argued by that time and you can get an order and come
or your lordship he'll raise all these points where he has raised here
petitioner is also granted liberty to raise all the points as has been raised in this present petition and any other point available to him at the time of arguing the application for discharge. All the disposal. All the points you argue, whatever you have argued, judgment, everything you show to that. You at least you have the High Court will have the benefit of the High Court trial court order on merits. Then we can go into.
charge trial
Discharge kariya pe koichi na mo. Not discharge kala pare that order you can challenge.
फटकी डेट पड़ुचे आगो भले लंबा डेट हो
Item 4.
Yes.
Lord, this is the application for quashing
Yes.
a criminal proceeding which was initially registered in respect of some of the offences which your lordship will find. But section 376 2N3 and section 67A of the IT Act 2000, those were not there. Those were included at the time of submission of the charge sheet. On the basis of statements which were recorded of the victim 3 months after lodging of the FIR. In the FIR, these allegations were not there.
Then is there any legal bar?
My lord, what I respectfully submit, my lord,
After investigation, these things came.
can come. My lord, what has happened during this period, she approached the accused, the petitioner before my lord, petitioner number 1, and her family members, his family members, that to say that the proceeding I am prepared to withdraw, you pay me a hefty amount of 20 lakhs. That also was brought to the notice of the police, and FIR was lodged. There also the charge sheet has been submitted. Your lordship will find that charge sheet. Here I have annexed also. That is on 5/11/2020. That charge sheet is under 8 series, annexure 8 series. This is the charge sheet against the victim who had approached, and they were highly educated. If your lordship will see the affair, there was a relationship for over more than 7 years. She was serving in Niger, and this boy was also serving somewhere, and they were in relationship. If your lordship may kindly turn to
Relationship, she asked a very less amount. You pay 20.
Lord, that's true, my lord. That
You
somewhere
pay 20 and get out of it.
somewhere your lordship may kindly come to.
I'll just issue notice.
Issue notice, madam.
Cross cases and all. I'll
Open
just issue notice. Issue notice to opposite party number 2. They are married or not?
No, my lord.
Are you
Now she is in relationship with another person. That is the problem.
That is your allegation. He wanted to marry you. You don't want to marry her. What to do?
My lord, no. Once she went to Niger, then your lordship knows the standard is probably elevated. There another.
Notice down CD.
CD call.
Stay of further proceeding in the
You
meantime.
move application. Land Council for the
I have filed, my lord.
seeks
Said application move.
Yes.
seeks leave of this name. Land Council for the petition submit that you would move application for the court below seeking adjournment before adjournment, owing to the fact that the matter is submitted before this court is not such application is being sent application.
Obliged, my lord.
Try and I'll send it to mediation.
Mediation is
If she
Yes.
comes, it's better that you pay
That's
some
your
money,
lordship.
pay some money and
Dispose.
shall I send right now?
Right now, let her appear because she may take it.
She the fact that she was asking 20 lakh rupees
That is true.
goes to show that she will ask a little more
That may be,
or
but
little less.
your lordship can send it to mediation only when the other party agrees.
Yes. Next.
Item 5.
My lord, pray for quashing of cognizance, my lord, order dated 31/8/2022, page 28, my lord.
Yes.
Though the compromise is there, possibility of chance of compromise, I pray for issuance of notice to the offender number 2, my lord.
What are the offenses? Okay, issue notice to open department. Yes.
Item 6.
Yes.
Possible, one part.
All right, today, why are you asking last time? What is this matter? You are asking for what? Huh?
They want to stall the trial, which is at the fag end, and all the witnesses have already been examined. It is closed on 17/5.
What are they asking here?
They are asking to stay the trial till the other accused persons, the trial of other accused person is completed, which is not possible in view of their own showing. Your Lordship may kindly turn to page 92.
19.
92. 92.
92. Yes.
Peruse the materials on record, including the petition. The present case has been targeted by the Honorable Court for completion of the trial by the end of the year 2023. Since trial of this case could not be completed within the stipulated period, prayer has been made before the Honorable Court to grant 6 months more time for completion of the trial of the case. The present case is at the fag end and of its trial. The accused person added as per section 319(1) of CRPC would face separate trial, and they would have got no relationship with the progress of this proceeding. As such, this court is not inclined to entertain the petition.
How will you get out of it?
As per my instruction, out of 50 witnesses, 22 witnesses has already been examined.
Whatever, your trial is segregated. The other trial which you want that should go on with you, the court has targeted. And the trial court could not complete and ask for extension of time. 6 month time is already granted to the trial court to conclude the trial. You want that your trial has to be tagged with that. How can it be possible?
Lordship, just one possible lordship, my senior lordship and another court. So just one possible lordship.
Also, it will not reach. I'll simply adjourn it.
Yes, lordship.
By that time, that trial will be over.
Yes, 17 it was
Adjourn.
obliged.
By the time the trial will be over, your matter will be in fact. Yes.
Item 7.
Because the High Court has targeted that
Yes,
matter.
sir.
I can't stall it now. That's the problem. Simply adjourn.
Obliged.
At the request of petitioner. Huh? Yes.
Item 7.
My lord, I am VC at Sambalpur. May I please, madam? My lord,
Yes.
the petition for the quashing of a FIR, my lord. The FIR has been lodged against the petitioner under section 406 and 420 IPC. The FIR is absolutely in respect of the civil matter, man. The FIR was instituted by one Khiroj Chandra Malik, who was chairman of the BISPO, who was NGO. My lord? Madam, my lord.
Investigation is still on, sir. Tell all these things to the IO.
Yes.
File a final report.
Yes, my lord. The FIR was lodged in the year 2020.
That's the reason the trial court has been asking them to file final form.
One line. The occurrence took place in 2008, whereas FIR was instituted in the 2022. Only FIR is available with the case record. The investigation has not proceeded.
The FIR is in 2020.
20. In respect of that, the NGO, BISPO, disbursed some loan which was not recovered. Consequently, this FIR was instituted after service of prior notice to the accused person who are petitioner in this case. So, absolutely it is a civil matter and FIR was instituted. All the petitioners are around.
Whatever the points he is raising, let him, the IO should consider it.
My lord, I
give the documents and whatever.
Are you on bail?
No, my lord. I have filed an IA for not to arrest. All are around 60 years old women.
Mr. Raghuda.
Hello.
I will.
Better, my lord, if I will take instruction and take on by my lord, urgent the matter. Whether investigation will complete or not, I will take instruction.
23rd?
Understand?
No courtship action.
Duty for it.
Duty for it.
Okay. Issue notice, call for the CD.
No courtship action.
And agents.
Both parties are.
Yes, yes.
Not essence.
But make it here.
Essence party.
Yes, party can see.
Party is
Why
not.
should party come?
Party.
Well, marriage lawyer is here and complainant there.
No,
They have to file
the
joint
problem. We need to know whether they are in custody or they are alive or they something may happen.
They can appear VC.
No, I'm sorry.
Let them appear through VC. I'm not insisting them to come to the court. At least we should know.
So my lord would like them to appear personally.
Yes.
So like
VC.
And also file joint.
I'll put it on 23rd.
joint application is already filed. Joint application is already.
I'll put it on 23rd. Day after tomorrow, because I'm sitting on the vacation bench.
Oh, I'm.
I'll do that.
Possible. On 23rd, my lord, the complaint matter may kindly be taken up as the first case.
Yes,
as the first case.
No problem, sir.
Obliged.
They also may say them to file joint affidavit with the Aadhaar cards.
You file joint affidavit with Aadhaar card and let them appear through VC.
Joint applications are complaint already filed. Affidavit.
Joint affidavit, sir.
That's an affidavit.
And affidavit, joint affidavit for settlement of the court. And Aadhaar cards, get the Aadhaar card.
Parties who will come appear, they will have their Aadhaar card.
Aadhaar card, and if they can't come, they let them appear through VC. No problem. Okay, 23rd.
Well, that joint affidavit within by 23rd may not be possible. So what I would humbly suggest, my lord, let the matter come up on reopening day, that is 19th of June, to be taken up.
Very well.
To be taken up as a first case.
19th June, the first case.
Obliged, much obliged.
First case. Both the cases. No problem. Yes.
Item 11.
My lord, 8, my lord.
9.
Compromise.
Sorry. Sir, item 9 actually what happened?
Item
Occasion
9.
both of yes, item 9. Both the parties had entered, had appeared before your lordship, and of course one accused out of 3 accused. Your lordship suggested let all 3 come, so we can dispose of the matter. But subsequently I found that 2 other accused persons were in custody in connection with another case.
That's the problem.
Yes, Lord. What happened? Now today another person who has been released on bail has come. So virtually there are 2 accused persons are present in this before your lordship. But so far as the other accused, third one, is inside the custody. So let him be appear through VC or.
He is in custody. How do you?
Yes, my lord. Trial is going on in VC.
Item 9, na? Item 9.
Item 9. Your lordship take up this matter any day after vacation.
Yes, that's a better idea.
But
Interim order to continue and let it come after vacation. So that by that time, who knows, he might get bail also. Yes. Yes.
Item 11.
Interim order to continue. 9. Yeah?
The matter is
Lordship,
now settled between the parties.
Yes.
On that day, I have read the 164 statement, my lord. The FIR has been filed when the petitioner did not turn near the victim and his family.
Forget about the.
My lord, having a child also.
There is a child.
But there is a hurdle because now 16 plus. The girl is 16 plus.
That's the problem.
And they have now agreed to get married after 18. Formal marriage, because there is a son also 6 months, 7 months.
Son is from
that fellow.
Only.
That fellow. He is all of that. The pilata party kortula to mato sepotu pothai
Who is
diju.
the informant?
Informant is the mother. They all have come. I am calling them because the pilata
The
both.
problem is that she is minor. In case is liable, after they got married, thereafter the case will pass. Otherwise, the case pass. Even if she will not accept her as his wife, my lord.
ନାଇଁ ସେଟା ତ ହେଇପାରିବନି କେବେ କାରଣ ତା ପିଲାଟା ଅଛି ମୁଁ ସେଇ ସଜେସନ ରେ ରାଜି ଅଛି let the trial be stayed and after attending
Trial
ଆଜ୍ଞା victim and
what will happen the time will heal also.
Yes,
What is their relation? They are very young.
They are staying, sir.
I'll stay the trial.
Yes, my
Let it come. By that time, at least.
My lord, after 1 year, after 1 year, it will
settle in their life.
1 year.
1 year, my lord.
1 year.
16 plus age is 17 plus.
Let it be, at least they will be settling in their life.
Yes, yes, my lord.
Give them time.
Yes, yes.
Simply, otherwise, the moment it is quashed, he'll start torturing that.
No.
You can't stand.
No, we cannot say the future about the future.
I'll just simply state and
yes, ma'am. Further proceeding may be stated.
At the instance of opposite party number 2, FIR number so came to raise the petition. It is stated with the bar that the counsel of the petitioner and opposite party number 2 are present. Any petitioner and opposite party number 2 are present in the court.
And the victim, my lord.
And also the victim present in the court. They are being represented by their respective counsel and identified by them. Okay. They filed the self-attested copy of
Joint affidavit.
and file also filed. Next. Then counsel for the party submits that the parties have settled their dispute and they filed a joint affidavit before the
They are residing jointly.
joint affidavit before this court inter alia, stating that petitioner number 1 and opposite and the victim, petitioner and the victim are staying together and there is a child born out of their wedlock by union. Then the counsel for the parties submits that the victim is 16-year-old.
16 plus.
16, about 16-year-old. She can't legally married petitioner. Therefore, although they are both the families are agreeable to the marriage, but for the age of the victim girl, marriage cannot take. Cannot lead. And on the ground of settlement, the petitioner seeks the indulgence of this court for watching the entire matter. In view of the aforementioned statement, I am not inclined to stay. I am not inclined to quash the FIR at this stage. However, the trial court proceedings. However, the proceeding pending before the court of
in the IA, I have stated. In the IA, I have
stated.
File court
is stayed till further orders. Release the matter in the month of September. October
की नवेम्बर रे आसु काना तार बयस भी हेइ नथु सेते
ए आसु जेबे au आइले आउट रेडी न कर दो कोन
एफिडेविट ता देबे नि जॉइंट एफिडेविट
फाइल कर जॉइंट एफिडेविट
and power of Mr. Raut also for OP
party and the wakalatnama filed by
OP number 2
counsel for the opposite party number 2 are taken on record. Simply adjourn and stay.
It is better, my lord.
Better out it has to stay by that time their relationship will be matured.
All are working in the shops.
Yes.
Your Lordship,
Next time when the matter will come, you will seek an adjournment.
Yes,
interim order to continue.
Yes, ma'am.
It will go on for some time. Yes.
34.
Lordship, I am on item 10 that has been skipped, Your Lordship.
I'll just take it up, Mr. Rai. After 34, there is some settlement matter. I'll take it up. Please wait.
34. 44.
Nobody is there left. Continue. Continue. Item 10.
10.
My lord, 8, my lord. Item 8.
Waiting 98. He's in queue compromising. Right.
Item 8, my lord.
I need to start around.
98. Settlement matter. 98. Yes.
Hello. Matter has been amicably settled. Affidavit has already been filed.
I am appearing for the infrared, my lord.
98, yeah? Yes, sir. Yes. Where are the parties? What is the offense?
323 and 3SS chapter.
341, 294, 323, 34 of IPC.
Who is this gentleman Satyabrat Behra? Kalandi
Das.
Kalia Das.
Na, Atikanda? Vipin Bihari? Pratap Das?
Abhiram? At the instance of opposite party number 2, FIR number 2, and the investigation is still going on. The investigation in the present case is still going on. At this stage, parties have settled that issue. Petitioner.
Charge sheet submitted, ba? Charge sheet submitted.
I'm asking.
We already have submitted.
After investigation, charge sheet submitted on? You don't know. You don't file anything. That's the whole difficulty.
Charge sheet filed on
TDC bar.
TDC bar 2013.
At this stage, the parties have settled it. Petitioners and opposite party number 2, opposite party number 2 are sitting in the court, being identified by the respective counsel, and the final self-respect of the joint affidavit. Where is the gentleman?
No joint affidavit. No joint affidavit. Separate affidavit.
The parties have filed separate affidavit. Affidavit dated 7/5/2024, inter alia stating that they have settled their dispute, and the opposite party number 2 is not interested to prosecute the petitioner anymore in this case. Mr. Maharaja appeals for the state and submits that since the parties have settled the dispute amicably, and the dispute is in fact inter se party, and all the accused persons are present in the court along with the opposite party number 2 and filed the affidavit before this court. There is no legal interest in quashing the FIR. Taking into consideration the answer and so it's quashed.
Abhiram ki kile?
Abhiram
Apna compromise hi jayto? Na. Compromise
এই যে চিন্তা বলে নাহি আমরা করিও কাজ চলো yes sir is saying something. Sorry, I'm extremely sorry to it's all right. I'm sorry, I couldn't follow.
I'm Samarjit Patnaik. I actually represent the matter in which Mr. Gajendra was appearing before your lordship a while back. I just wanted to mention 2 facts. Out of the 5 accused who were named in that FIR for which we are seeking the quashing, 2 are the ex-employees now. So 2 have already left the company, and 3 of the executives are based out of the Macmillan Publication House, Delhi office. So my only humble request is if your lordship could permit them to the Delhi executives to at least appear through VC.
That's what I told. Let all the accused appear through which I have no issue.
No, I wasn't aware because certain high courts, I mean in Delhi, of course, the high courts are allowing.
Just their presence should be there. That's all.
Yes.
So we will appear through VC, no problem.
And the 2 accused who have already become ex-employees, would that also be applicable to them if they can?
Yes, yes. All of them can.
But we will file their affidavits.
You file the affidavit with Aadhaar card.
Yes.
And let them appear through VC, no problem.
And if that could come in the order, I don't know whether the order sheets are if.
I'm telling you, I need not write because it's a settlement matter. Why should I tell in which manner you will appear? Once you are appearing, that's the reason I'm fixing it on 23rd. But that day that
grateful, your lordship. Great.
Also, one more thing, interim order passed on 4/1/22.
That will continue. Next date appearing.
4/1/22.
Interim order will continue that matter.
Much.
And are you interested on 23rd or?
No.
After
It's better on the opening day, that is 19th.
Reopening 19th.
That will be a very short.
Done.
So you have to negotiate.
Much obliged.
Go back.
To prepare the affidavits and file it. Much obliged.
Thank you. Yes.
No, regular.
Yes. 10.
8 one.
8. Okay.
Item 8.
May I please, your lordship? I am on VC, my lord. Against the order of rejection of a
display
petition filed by the petitioner, under section 311, my lord.
This is also the item 8.
Yes.
Item 8.
Yes, Mr. Rai.
Item 8, my lord.
Yes.
Here, my lord, the petitioner has approached this honorable court against the order under annexure 1, my lord, where the learned court below has rejected the petition filed under section 311 of CRPC.
Okay.
Here,
Who is that PW2?
Victim, my lord.
PW2 is the victim, my lord.
Where is your application under 311? Yes.
My lord, under annexure 4, my lord.
Now, what are the questions you wanted to ask?
In my lord, the fact remains the 1710, the date of incident, my lord. 1710. It's a holiday, my lord. Holiday, and it's a Sunday, and also a holiday.
You come to your application and pay annexure 4.
Annexure 4, my lord.
This is a question or this is the answer?
This is question. He wants to.
No, I think this is the answer you expect from the.
Exactly.
This is not the question.
Sunday,
Just read it. Read it.
Yes. I have seen this.
This is the answer you want. You want from the victim that he should say yes.
Yeah.
This is correct.
Because she says while she was preparing herself to go to school, the accused came and
you tell me from your experience, can these two be a question?
Lords may allow for best interest of justice.
You have no answer to this. These are not questions. One paragraph answer, you have said everything. This is the answer.
Okay. Yes.
So the trial court is rightly rejecting the application.
The press out of movement.
Trial court says.
Another thing, my lord, the victim is even Foxo is there, my lord. 6 Foxo is there.
Petition is agreed by the order dated 24/11/2023, whereby his application under section 311 to recall the PW2 has been rejected. The petitioner wanted to recall the witness, the said witness, and the victim to ask that view of the matter, I am not.
The trial court also rejected the application under section 33 sub 5.
That I read. In that view of the matter, I am not inclined to entertain this petition. However, dismissal of this petition shall not preclude the petitioner to leave any other evidence. Yes. Thank you.
Item 10.
May I please, Your Lordship? Your Lordship, the NDPS issued on 31/7/2023, Your Lordship, page 16.
Yes.
And she was on bail, Your Lordship, on 24/8/2022.
Paying something you have bail on
24/8/2022.
NBW 31/7/2023.
Yes, Your Lordship.
Pay 500.
Yes, Your Lordship.
Item 13. Item 39. Compromise. And I prefer kindly take it for observe that.
Yes.
Item 14.
My lord, taken this was after vacation.
After vacation.
Yes, sir. Obligation.
Beg pardon, Your Lordship. My Lord, here the petitioner challenging the criminal proceeding, my Lord. So also, Your Lordship may kindly refer the page number 14, that is a prayer person, Your Lordship.
Yes.
Passing of the criminal proceeding, or in alternative, this honorable court may pass an appropriate order to release the petitioner on default bail from judicial custody in term of section 167, subsection 2 of the CRPC, Your Lordship. What happened in this case, my Lord?
There are two players, madam.
Initially, my Lord.
I think in this petition you are trying to take a chance.
My Lord, what happened in this case,
You
my
don't
Lord?
have a case, you know yourself, but you want to take a chance.
Your Lordship,
You're making all kind of praise. Anyway, you tell what is your case?
Your Lordship will decide, my Lord.
Yes.
Here, my Lord, what happened? A FIR registered, my Lord, against the persons that is under section 21B, 25, 29, and 27 of the NDPS Act, my
Hey,
Lord.
you talk about that 167(2).
My Lord, 167(2), why it is applicable, my Lord? Because till date, my Lord, the prosecution not filed any charge sheet against me, my Lord. The charge sheet filed against the other accused person in respect of other accused person, not against me. Since, my Lord, 3 August 2022, I am in judicial custody.
But he has to file petition there, my lord, before the trial court.
Already filed, my Lord. That is,
No, but what is the position? If there are 5 and you file all of them are present. Suppose you file preliminary charge against 2 of them, and you don't file the charge sheet.
He has to file. They are the petition.
No, that's a part. What will be the position? What about the 3 people against whom you have not filed a charge sheet at all? You said that for you investigated and against 2 you have filed, 3 you have.
They have to approach that court, my lord.
Two separate questions. Suppose, my lord, A, B, C are facing trial, or they are in custody. In between, charge sheet has not been filed. The window after 180 days, no application filed by the prosecution to extend the period of investigation or any other things. Then they are having a good case. C, D, E, they are absconding. Question there prevails. C, D,
Hey, once you are absconding, 167(2) is not applicable. Not there. But there, obviously.
the absconder there is no
but this is not a case of.
No, that's what I started saying. If there are 5 accused persons,
yes,
all of them are in custody.
Yes.
You investigated and filed the charge sheet quad 2, saying that these 2 have done it, and so far as the other 3 is concerned,
it will go.
Then 167.
Yes.
Is this your case?
Yes, my Lord. This is,
are you in custody?
Yes, my Lord. I am in the custody. I am not the absconder in this case, my Lord.
Then you
show me. Then I am giving you liberty. Won't move up.
Yes.
Yes, Your Lordship, I am already moving application before the credit
Where is that? Where is that?
That is starts from page number 145 to 150. 145 to 150.
150.
145, my Lord. 145.
দেখুন তো 145.
My Lord.
Yes, 145. I'm there.
The petition under section 167 subsection 2 filed on behalf of the accused Sanu Mahanto, the present petitioner, release him on default bail is taken up for consideration. I filed this application, but my prayer is, my Lord, for the.
No, you read it. Don't give commentary. Read it. What was the court's?
It's a lengthy order, my Lord. They are saying.
Lengthy, you can't read. Shall I read it?
No, my Lord. Sorry, my Lord. I am reading.
What is this lengthy? I will not read it.
My Lord, I am reading.
You are not prepared, it seems.
No,
you have raised a very good point.
My Lord.
But substantiate it.
My Lord.
Shall I put it on 23rd?
Yes, Your Lordship.
Okay. Let it be on 23rd. This is a substantive question. If you get substantive, you have to establish that on facts.
Yes. My Lord. I am also covered with this honorable court's judgment.
No, forget about that. You just simply tell me if you are in custody, if the charge sheet is filed for the other accused person, those who are in custody,
Yes,
For them, 167 doesn't lie.
My
But
lord.
since no charge sheet is filed against you,
Yes,
therefore
my lord.
167(2) is applicable to you.
Yes.
My
That
lord,
is the
my
whole
lord.
case.
I
And
will
you
see.
substantiated that on the basis of facts of this case.
Yes,
Okay.
Your Lordship. Grateful.
23rd. 23rd.
Grateful, Your Lordship.
Yes. Mr. Raghunath, just check it up. Okay.
I will grateful, my lord.
My lord, here, the offense alleged against the present petitioner is 20B Roman 2C, 25 and 29 of the NDPS Act. My lord, initially the FIR was registered under Annex 2 at page 16 against one Kartik Sabur who was in the vehicle and driving the car. Admittedly, it's a commercial vehicle. I am not even the owner because owner is somebody else. I had taken the vehicle on lease and I am running the vehicle. Vehicle was given mine. It's a commercial vehicle. Charge sheet was filed against me. My lord, I am questioning that no case is made out against the present petitioner on 2 counts. My lord. First count is I was never present in the vehicle. None of the statements implicate that on my direct instruction, the vehicle was transporting the contraband. The second point is, my lord, I am not even the registered owner of the vehicle. The registered owner is somebody else. He should have been charge sheeted, not me. I cannot be charge sheeted because the vehicle doesn't stand in my name. These are the 2 points which I am raising. My lord, yes, I am aware an anticipatory bail was filed, which was turned down against me. I am aware of that. That point will be raised by my counterpart. That's why I am saying it beforehand. But question is, my lord, when there is no iota of material against me, can I be charged?
Where are the 161 statements?
My lord, that your lordship last occasion hearing had asked the state council to
We have
produce the same.
Maharaja.
No. Only because, my lord, my friend has prayed for an adjournment. That is
No,
why
I have not prayed for an adjournment.
Logistic. See, the issue is there are two points he raised.
Yes.
There is no conscious position because he was not there.
Not there. Yes.
But the vehicle used in the crime.
Yes.
On the basis of that vehicle, he has been roped in.
Yes.
As an accused.
Yes.
He is not the owner of the vehicle. He is the person who had
taken it on lease from the real owner.
That is not the prosecution case.
Yes, that is the point I am
That is the charge sheet has been filed, Your Lordship.
I am raising that point.
Page 36, Your Lordship.
Yes.
Page 36.
Factually, whether it is correct.
My lord, yes. All sincere efforts, my lord, para 2. Para 2, just 2 lines from bottom. Para 2. That's what it? I arrested him.
36, na?
36 page.
Read the para during.
Well, I'm reading. During course of investigation, I visited the spot. We seized the seized articles from SIL Dasra, pay for inventory to Hon'Ble JMFC Mohana, sent requisition to RTO Gajapati for supply of ownership details. Submitted detailed report to SP Gajapati, sent the exhibits to RFSL Barampur for chemical examination and opinion. And MO opinion is awaited. Efforts have been made to comply with mandatory provision of the NDPS Act. As the prima facie evidence under section 20B, 2C, 25/29 of NDPS Act is owing without against the accused person Kartik Sabur, son of so and so, district so and so. I arrested him in this case at 3/6/2022 at 11 p.m. Provided to the Honorable Court on 4/6/2022. All sincere efforts have been taken to nab the owners of the seized article of these vehicles, seized vehicle, and then Sri Rajkishore Das, OPS DSP Rajpati, was used to supervise the investigation of the case and attended his supervision. So now, my last, the above noted accused person showing accused person 1, 2 as absconder, 1 arrested, 2 absconder, 2 is the present petitioner.
So what it, where is the material that I am the owner of the vehicle?
Where is the material that you are?
I produced the RC book that the vehicle doesn't stand.
No, you made an opening statement that you are the.
I am not the owner. I have already your lordship may post it up presentation. I produced the RC. One question. This is one question. If I am not the owner from my side, my lord, the second one is.
If you were not the owner,
yes,
you should not have absconded. You should have said, told the court, told the police that see, I am not the owner.
I have brought it from the net. I have brought it from the net. One is Nirakar Jina is the owner of the vehicle.
That should have been told to the police, investigation officer.
Yes.
And instead of doing that, you went and filed an anti-debit bail.
Exactly.
It is rejected.
Exactly. Can I dispute that I have not moved the NCP?
That is not the issue. Is
when I will go, when I will produce the material, if I go to the police, I will first behind bars. I will first put behind bars.
That's a different story. But I am basing it for the purpose of Quashing.
Yes. So, once I go behind bars, what material I produce?
Is that the case for 482?
It is not.
You might have gone to the bar.
Therefore, NDPS. It is not a 506 that I want to put like that. I will give it a 41.
You have not filed any document.
I will produce the document. Nirakar Sahu is the owner of the vehicle.
173 is 8 is open.
Charge sheet has been filed. So
you file the document. Land Council, most Land Council submit that you will be filing additional document to substantiate the case, release the matter. You file it in.
Your lordship post it on 20th. I placed that.
20th and 161 statement of it.
Yes, that your lordship may not be able to produce the 161.
CD call.
Yes. 20th of June.
20th.
Great.
Item 17.
May I please, Lordship? My lord, the present petition challenge the order dated 21/4/24 passed by the Lord and STGM Puri in Masses case number 207/2020. Because the complaint petitioner allowed by the Lord and Court will under section 143A of NI Act.
You are thinking.
My lord.
Page 24 years. Last paragraph. Page 24. 24. Therefore, keeping in view, madam. May I read it? Yes, keeping in view of the said provision on the decision and cited above, it can be concluded that this court can direct the accused, who is the drawer of the check bearing number so and so, to pay interim compensation to the complainant.
143.
Yes, but 143. So 20%.
My lord, as per the Supreme Court decision earlier, the provision of 143A clause 1 supply A, that is the provision AML. May, my lord. This is not a this.
Why should I interfere?
The decision, my lord, taken on the.
Say that if you have a, what is the check amount?
Sir, 3 lakhs, 6,000.
The court is asking to deposit 40,000.
My lord.
Why you come to Supreme Court for 40,000?
40,000.
40,000.
Actually,
next, 40,000 very good order. Needless to say that if the accused is acquitted, the complainant shall repay back the problem.
My lord.
If you have any problem, why should I do for everything? Burdening the court. And if you have any problem in paying 40,000 rupees, move application. I'm giving you that limit. The petition is to withdraw this petition. Petitioner has challenged the order dated 21/2024, whereby the court below by taking while mentioning court below that directed the petitioner to pay 20% of
interim compensation.
Take amount. Yes, and interim compensation. Yes, as per the minutes of section 143 capital of the petitioner agreed by the state of I'm not going to get the matter. However, we are intended to the application for mediation. the same order. The application is moved, so the same side. Move application. Yes. 18 disposal.
Belgium matter. Yes, NBW 22/7/2022, bail 19/1/2021.
500. 20. 20.
19.
19. 18 ಹೇಗಿದೆ
20 ಹೌಚಿ ಮತ್ತೆ ಬೆಲ್ಜಿಯಂ, that is NBW 21/10/2022. Well, the 20 into subsequent application date. देखो
22 there are two matters.
Yeah, two matters were allowed.
First matter allowed.
First matter that is not my matter. That is not the appearing from VC mirror.
But that is allowed.
That's allowed.
What about the sub-item?
Okay.
22 is lead item. 1885 of 2024.
Yes.
That is already done. And in so far as 1905 of 2020.
In this case, what the office has gone to informant for the appearance period.
Say equal opera. Say petition is same. Petition.
Awaiting notice.
Yes, yes.
Exactly. Awaiting notice.
Interim to continue.
Interim. 23.
23. 22 also Belgium matter, NBW 13/11/2013. Bail 7/5/2013.
13, huh?
Yes.
PWI also 13.
13.
Oh, 1000. 24.
May I please show? Telling in the criminal proceeding, my lord, on the ground, my lord, in a similar set of evidence, my lord, the principal accused and other person have been acquitted, my lord, after a full-fledged trial, my lord. Offense under section 20B2C of NDPS Act, the findings of the lauded trial court, page 131, paragraph 23. Paragraph 23.
Chemical analysis report was there.
Yes.
Already there.
That is it.
Then you are not covered by one bill.
Lordship, see the findings, my lord, 131, page, paragraph 23.
131.
Yes, my lord, paragraph 23.
Again on merit, na?
Yes, my lord.
Anyway, 131.
131, page. The prosecution examined other witnesses to establish the fact of seizure of ganja. The independent witness did not support the case of the prosecution at all. The official witness have stated about the recovery and seizure of the contraband ganja. The principal witnesses in the case are PW 10 and 18. As discussed above, there is no coordination between the evidence of PW 10 and 18. PW 10 did not comply the requirement of section 50 of NDPS Act. PW 18 failed to comply section 42, 57 of NDPS Act. In this view of this matter, this court is of the considered view to hold that the evidence of PW 10 and PW 18 are not sufficient to hold the requirement of mandatory provision of the NDPS Act. Yes, sir, comply this.
This is
what more remain, my lord.
This is all assessment, and his absconder anticipatory bail was filed. First or second order was given. It has not been complied. 9/11/2000.
That is a different aspect. What is the merit of the
10
case?
and 18, how will you prove now? 50 is not complied, 42 is not complied.
Nothing has been
How will you sustain the conviction?
Direct to with this judgment, they can avail that.
And your lordship, in similar circumstance, my lord, your
Because it's
lordship
a
has
case
quashed the
point,
proceeding,
yes,
my lord. Your lordship has quashed the proceeding in similar circumstance case.
Who has passed?
Your lordship has.
I am not entitled to commit mistake.
No, my lord, your lordship has quashed. This is the reported judgment.
But see, the problem is you have been absconding since.
Principal accused.
You have been absconding.
Yes, that is
This judgment, my lord, chemical analysis was not there.
That I know.
But here, my lord, 42, 50,
But
57,
here,
nothing has been complied of.
10, 18, their prime witnesses, 50 is not complied, 42 is not complied. So therefore, acquitted.
They have, my lord, full-fledged.
Ultimate result will be what? Ultimate result will be acquittal.
What I'll do is I'll expedite the trial.
No, my lord.
So
Ultimate
concluded within 3 months.
Ultimate result will be, my lord. Ultimate result will be the ultimate.
See, but they face the complete trial.
Yes, my lord. When the principal accused acquitted, my lord, what more remain, my lord?
Therefore, I 3 months.
No, my lord. When the principal accused, ultimate the chance of
Therefore,
conviction.
I'm protecting you till 31st of June. APS. 3 months time I am granted to the trial court to conclude the trial because there is nothing.
Yes, ma'am.
Immediately it will be done.
objection
Observation I keep, right. I'll write down that
Till that
paragraph also. And thereafter.
Subject to consent, they will appear before the court.
Natural.
No, Kalkinto.
Without a fear how very then counsel for the petitioner passing up for the entire criminal prosecution initiated against him. Admittedly, the petitioner, how many petitioners?
My lord, one petitioner.
Admittedly, the petitioner has been absconding. As a result of which the trial was split up. And how many accused persons were put to trial? And the four co-accused persons.
Four co-accused
were subjected to trial. The additional district and session judge Navarangpur by judgment dated.
No, my lord, Umar Court.
By judgment dated 29/9/2023 in TR case number 5 of 2021 recorded an acquittal in favor of all the four accused persons, those who have paid the trial. In the Mr. T.K. Mishra and counsel for the petitioner taken me to the judgment, the reasoning of the judgment by which the accused persons were acquitted. He relies upon para 23. Para 23 of judgment, page 131, para 23. Which reads agenda. He submits that in view of the fact that the main witnesses, namely PW 10 and 18, the testimony of PW 10 and 18 has not been relied upon by the court below in view of non-compliance of the requirement under section 50. 42, 50 and 57 of NDPS. Yes. The 42, 50 and 57 of NDPS. The testimonies were discarded. And the petitioner and the co-accused persons have been acquitted. In that view of the matter, subjecting the petitioner to the trial will definitely be a futile exercise. Because the petitioner would be definitely acquitted. Mr. Maharaja then counsel for the state submits that the acquittal order recorded in favor of the co-accused person is after a full-fledged trial, and the evidences recorded vis-a-vis those accused persons. Therefore, the petitioner petitioner being an absconder, cannot avail the benefit of the acquittal order. Taking into consideration the aforementioned facts and circumstances, I am not inclined to quash the proceeding against the petitioner. However, petitioner is directed to appear before the court on or before 30th June in 2024 and move appropriate application before the court below in accordance with law. If the in the event the petitioner surrenders, the related trial court should do well to see that the trial is concluded as expeditiously as possible, not later than 3 months.
Subject to protection. Subject to interim protection.
Subject to
interim protection. In
period till the petitioner appears before the court on or before 30th of June, so and so, no court will be certificate. Till June, I am protecting. Go and appear, and 3 months trial will be complete. I don't think better order could be passed. Yes. 25. 25.
Lordship, the petitioners filed challenge for quashing of cognizance. The Lordship, matter has been already set up, and due to monetary transaction, this 160 case has been filed, and the money has
Where are they? Bring them.
My Lord, your Lordship has also.
My Lord, I am appearing for opposite party. I have no objection.
You may not have objection, but where is your client? We will ask him. He has bring them.
Yes.
23rd? 23rd? Day after. Because I am sitting on the vacation day. 23rd of June. Bring them on 23rd. Yes.
26.
Oblige.
May please, your Lord. Yes, Lordship, the petitioner is challenging the cognizance order dated 31/7/2023, your Lordship. The offense, this is a money transaction between the informant and petitioner, but the other two accused persons are the relative of the informant, your Lordship. He has taken the hand loan as per the allegation, your Lordship. The present petitioner is a son of the other two co-accused persons, your Lordship. So, the present petitioner is working in a company, private company, your Lordship. So, he has no role at all, your Lordship, in this case. 26. I have annexed also, your Lordship, that is the final form under Annex 3, page 21.
21. Final form filed in favor of.
Sorry.
Okay, it's filed. Yes.
Yes.
It's filed. Yes.
Final form also submitted by the IO, your Lordship.
Why should I pass?
Because of your Lordship, the other two accused persons, they are the father and mother. The present petitioner is the son of the other two co-accused persons.
That's why
So he is no way to any role of this case, your Lordship.
you show me nothing, no allegation is made against you or something of that sort.
Your Lordship, kindly turn to the 161 statement of the informant.
Who has taken the loan? Your parents have taken the
Parents.
loan. What you want to tell is, my parents have taken the loan, I have no role to play, so therefore why should I be tried? That's what you are saying. Show me
the
whether
present,
your parents have taken loan and they have defaulted, therefore this case is filed against them.
your Lordship, you kindly turn to page, your Lordship, on Annex 3, the running page 31. Page
Yes,
31.
read it. Just see. Read it.
ମୋର ନାମ ମନୋରଞ୍ଜନ ସ୍ୱାଇଁ, so and so ମୋର ସମ୍ପର୍କୀୟ ଦୁର୍ଗା ଶଙ୍କର ମହାପାତ୍ର, who is a father of the petitioner.
Durga Shankar Mahapatra.
Yes, and Rita Mahapatra. And the present petitioner is Samit.
Samit Narayan.
Yes.
Narayan.
ପଇସା ଦରକାର ଥିବାରୁ ସେମାନେ ମତେ ପଇସା ମାଗିଥିଲେ, ତାଙ୍କର ଏକ ଇଟା ଫ୍ୟାକ୍ଟ୍ରି କରିଥିଲେ ଏବଂ ସେମାନଙ୍କର ଇଟା ଫ୍ୟାକ୍ଟ୍ରିରେ ଭଲ ନ ଚାଲିବାରୁ ସେମାନେ ବ୍ୟାଙ୍କରେ ତାଙ୍କର ଏକ ପ୍ଲଟଟିକୁ ବନ୍ଧ ରଖି କିଛି ଟଙ୍କା ଆଣିଥିଲେ। ବ୍ୟାଙ୍କ ସେମାନଙ୍କୁ ନୋଟିସ କଲା ଯେ ଟଙ୍କା ସୁଝିବା ପାଇଁ, କିନ୍ତୁ ସେମାନେ ପାଖରେ ପଇସା ନଥିବାରୁ ସେମାନେ ମତେ ଆସି କହିଲେ ଯେ ବ୍ୟାଙ୍କକୁ ଟଙ୍କା ସୁଝି ଦିଅ, ସେଇ ପ୍ଲଟଟିକୁ ତୁମ ପାଖରେ ତୁମ ନାମରେ ରଖ ଯେ ପର୍ଯ୍ୟନ୍ତ ଆମେ ତମକୁ ଟଙ୍କା ନ ସୁଝିଛୁ। ସେଇ ଫ୍ୟାକ୍ଟ୍ରି ଓ ଜାଗାକୁ ତମ ପାଖରେ ରଖ। ଏସବୁ ମୁଁ ଜାଣି ସେମାନଙ୍କୁ ବଜାରରୁ 29 ଲକ୍ଷ ଟଙ୍କା ସୁଧକୁ ଆଣିଲି ଓ ମୋ ପାଖରେ କିଛି ପଇସା ଥିଲା। ଏମିତି ମୋଟୁ 45 ଲକ୍ଷ ଟଙ୍କା ମୁଁ ତାଙ୍କୁ ବ୍ୟାଙ୍କ ଚେକ୍ ମାଧ୍ୟମରେ ଓ କିଛି ହାତରେ ଦେଇଥିଲି। So my prayer before you,
right, read it. ସେମାନେ ପ୍ରଥମେ ମତେ
ସୁଧ ଆକାରରେ ପଇସା ଦେଲେ, ତାପରେ ସେମାନେ ମତେ କିଛି ପଇସା ଦେଲେନି। ମୁଁ ତାଙ୍କୁ ପଇସା ମାଗିବାରୁ ସେମାନେ ମତେ ଖରାପ ବ୍ୟବହାର କରିବା ସହିତ।
What about that plot? Plot you have given to them?
A plot that already clear the loan amount by the borrower, and that has been released from the bank, your Lordship.
You have taken 45 lakhs.
No, your Lordship. 45 lakh se, your Lordship, for a moment, kindly turn to.
But why are you saying that you are not involved? Three of you are.
Because of the present petitioner is a son, your Lordship.
Then
the entire family.
Your name is specifically given in this statement by the complaint.
ସେଥିରେ ଟଙ୍କା କିଛି ପୁଅ ପାଖକୁ transfer ହେଇନି କି ସେ ପୁଅକୁ କିଛି ଦେଇନି। Unnecessary, he is entailed in
Not
this case.
unnecessary. Your name is there. You will pay, settle the dispute, then I will issue notice.
Kindly issue notice to the.
Simply issue notice. Simply issue notice.
Till then, protect your Lordship, because of he is working in a private company, your Lordship, and moving forward.
FIR is registered and investigation is still on.
Yes.
You have applied for anticipatory bail.
Already on bail, your Lordship.
And then what protection?
Because of any time, your Lordship, the NBW can be issued by the trial court.
On apprehension, I will pass an injunction order. injunction against all the courts that no
Yes.
action should be taken.
He-
You tell me any adverse order is passed, then I'll, if NBW is issued, I'll pass it. Show me.
Because of your
Simply
lordship,
issue notice letter.
as per the condition
You
by
get
the
ready,
trial,
get ready with the money, pay.
as per the condition by the trial court, the accused person shall be appear in each and every day, your lordship.
You are not VIP, you have to appear. What is the problem? Yes.
So only
No, issue notice.
the present petitioner can take
You have to appear.
take an adjournment before the trial.
Why adjournment?
The present petitioner, not the other co-accused.
Why? You tell me why.
Because of your lordship, he is moving throughout the India, your lordship,
Let
he
him
is
go.
working
What
in
is-
a
what is the
private
problem?
company.
Now investigation is only on. You are protected by the court. What apprehension you have? Nothing.
It is the difficult part of the petitioner to appear before the trial court, your lordship.
When is trial court
Each
investigation
and
is
every
going on.
day. your lordship.
317 petition file.
Investigation is no, investigation is going on. That's what he says.
No.
The condition is that your lordship.
Trial stage. Trial stage.
Trial is going on.
Yes,
Then
yes.
move application
Trial
to
stage.
317.
Only your lordship,
stop.
only that permit, your lordship.
Yes, he is posted for trial.
Yes.
A trial.
Yes.
And he is on bail.
Yes. He is on bail. That is not dispute.
But that condition is there, your lordship.
Condition is there, then move application. Where is the condition? Show me.
Yes, if
Show me
your
the
lordship.
condition. Where is the? You should have moved an application for variation of that condition. That would have been better for you.
Your
It
lordship,
says that
page-
petitioner shall appear
page
in
18.
person before the learned court below
Yes.
on each date of posting.
file modification
You file a modification application because this condition is taking away your right to move application under 370.
Yes.
Therefore, I'm interfering in all the matter where there is a condition.
As a condition modification file.
You have a statutory right under 370.
Yes.
You can move the application for variation of that part. Notice करके इधर करो. Next.
Yes, sir. Developer.
Well, my lord, I had applied for certified copies.
1 minute. Mr. पढ़े लिखते हो देखो. Mr. Maharaj.
Sir.
Why should unnecessary he will move application? Shall I just say that that condition will not preclude him to move application under and if such application is moved, same shall be considered on.
Yes.
Why unnecessary again another petition?
Sir, dispose.
Right on. I will not interfere but this much I will.
Yeah, that one.
Yes. Right on. Where is that? Where is that order? Where is that order? Page?
That is page 18. your
Item number 26. 26 थिला ना?
26.
26.
This to the-
Page 18. 18.
18. Yes.
Condition number 1.
Right on. In the present petition is seeking quashing of the entire prosecution initiated against him. I am not inclined to interpret this matter. The trial is going on. Mr. Learned Counsel for the petition submits that by the order dated, where is that order dated?
That is
21/7/2023. His client has been enlarged on bail. However, a condition is imposed to the effect that he shall appear in person before the learned court below on each date of posting. Because of this condition, his right to move application under section 317 is taken away on each date of hearing, he is bound to appear in the court, want to appear in the court. He submits that the conditions so imposed may be varied, taking into consideration the fact that you are working,
yes, in a private company.
Taking into consideration the fact that the petitioner is employed in a private company.
Yes, and moving throughout the India.
And undertaking journey, going to his work profile, he cannot appear in the court on each and every day. Therefore, his right to move application under section 317 CRPC cannot be taken away by imposing a condition. In that view of the matter, the condition so imposed is modified, and the petitioner is given liberty to move application under section 317 CRPC as and when it needs to arise. Such application is moved, same subject. I know that observation petition is disposed. Yes.
27. My lord, here, my lord, it's a small matter.
Yes.
NBW was issued against the present petitioner. Now, my counsel lordship applied for certified copies. Along with it, he filed a wakalatnama. That copy application was rejected, stating therein that since a direction was made for execution of NBW and production of the accused, the wakalatnama was not accepted.
Which order is that order?
Page 50.
Page 50, my lord.
Order dated 25/4/2024.
No, see, order I can't read it. What is written?
I am reading, my lord. It's so difficult to read. So difficult.
By the
By the order dated 5/4/2024 has not accepted this wakalatnama filed on behalf of the accused by learned defense advocate Sri R.K. Dalai in absence of accused against whom NBW.
I have cancelled the NBW. Go on appear. Give
NBW data. We
had applied for certified.
It's all right. Give me the NBW order. I'll set aside that. The court says that in the absence of the accused against whom NBW is issued, somebody is filing wakalatnama, I will not accept.
And
that is what it says.
Because the another advocate was there in.
So no objection.
That is.
But I'll set aside the NBW order itself.
Yes.
Go and appear through the counsel. Tell me the NBW order.
No, please tell
me take up day after tomorrow. I have to take
23rd.
Yes.
23rd. Tell me the NBW order.
My lord.
I'll pass that order.
My lord.
And allow you to appear through counsel and move whatever application you want. Yes.
28. May I plead the law? Well, the petitioner is accused in a case for commission offence under section 130 Act. The case was posted on 16/4/2024. That is at running page 13.
Yes. What happened there?
For defense evidence, my lord.
Yes.
The petitioner filed a time petition with a supporting with a medical document, my lord. That was rejected, and the case, the defense evidence was closed. Case was posted for argument. Only defense.
Where is your application? You moved.
My lord, I am placing, my lord.
Land counsel.
Accused is absent, allowed to be represented under section 317 CRPs for today only. Learned counsel for the complainant file Hajira. Learned defense counsel file a petition seeking time to adduce evidence on the grounds stated therein, support of with the Xerox copy of the medical documents of the accused. Copy served. Learning counsel for the complainant vehemently objected to the petition for time had. On perusal of the case record, it is found that.
Can I allow it in ex parte?
Ex parte 130 in it, set a problem.
No argument पक्की देचन ना जजमेंट कर देबे
केबरो 138
2020 रो केस
successfully 4 years you could
नहीं 23/2/2024 रे थिला एविडेंस फाइन
when is the next date appearing?
The case is lingering since 23/2/2024 for adducing evidence from the side of the accused person. 23/2 ରୁ 16/4
lingering from 2020.
No, 2020 mo part nahi.
That's what he says.
Case of the year 2020.
February
2020 February 2024 ରୁ linger करछि evidence.
When the next date appearing?
थिला 24/4/2024 सेना कोर्ट नथिले तापर रहितला ई 22 तारिख लास्ट माने से ए जो 21 तारिख आज अछि माय लॉर्ड
आज सर्दियो
ना आर्गुमेंट हेई ना आज मत टाइम पिटिशन देइ छ ई कोर्ट रे फाइल करछन बोली देखै कि टाइम पिटिशन रे देइ
मिल गेला टाइम मिल गेला
माय लॉर्ड
आज मिल गेला केबे पई
सेटा मु बुझि ना
you tell me the date on that day I
launch
tell that
my lord
that day you will
my lord just pass over I will
yes you just tell me when the next date appearing
my lord
what I am proposing to pass the order is on that day
my lord
you will adduce your evidence
my lord
that only one day
my lord one day.
And I'll allow it
just pass over I will
yes ठीक है but because I'll issue notice again it will be further delay It's better that one day you lead your evidence and next day matter will be.
May I please, Lordship? My Lord, I request my Lord to hold the brief number CRLMC 1915 of 2024. The FIR is quite visible for that reason. The second list.
1915
of 2024.
How many? How many? 4 cases.
My Lord, all are from the same FIR, my Lord.
Different accused.
My Lord.
Same FIR but different accused have filed different.
My Lord.
Okay. Yes.
I request my Lord to hold the brief of 1915.
Yes, 1915.
My Lord. My Lord, I am challenging the cognizance order dated, my Lord,
Yes.
3624. My Lord, 3624, which is a running page number 31. Offenses under section 147, 148, 149, 307, 385, 435.
What are the?
My Lord, what are the facts of the case? Just briefing it within 1 second, my Lord. Hitachi machine, it was buried under DRS and query. The operator name was Sagar. Few persons came down along with swords and all these things. They have set fire on that Hitachi machines and they have tried to give a blow to the person, but Sagar, he went away and he is right now having no injury, my Lord. That Hitachi machine has been set to fire. While investigation was taking place, it was found that one Biswajit Oraf Holix Naik, who is the prime accused, along with Raghuram Rauta, they have previously extracted money from this Hitachi machine owner, Pradeep Dora, who is the informant over here in the FIR, and 50,000 has been ransom money has been taken from this. These two persons, Holix Naik as well as Raghuram Rauta. In that case, my Lord, my only point is that because alias Sagar, who fled away from the spot, has identified two persons. One is Raghuram Rauta, another is Biswajit Naik. Biswajit Naik has said over here in his statement, my Lord, accurate sentence I'm getting it, my Lord. Mote Biswajit Oraf Holix Naik o tara sango Raghuram Rauta mo pakhaku asi mote कहला कि तो मालिक को कहो हमको बट्टी देबा नहले हमें ताकू छाड़ीबुनी 50,000 rupees was given. Number 1. Number 2, my Lord. जदि ठेंगा मोर मुंड को बाजी था मोर मृत्यु निश्चय होता दूर को आसी मु देखिली जे विश्वजित और हॉर्लिक्स गाड़ी टी को निया लगाउछि. Prime accused person is the this. Neither, my Lord, any injury has been done to this person. Sagar 307 has been attributed, cognizance has been taken. Neither 385 ransom money has been taken by all these four persons. It is attributed to Biswajit Naik and Raghuram Rauta. Number 3, my Lord, 435. This person, Raghuram Rauta, Holix Naik, he has set fire on the blaze of that Hitachi machines. My Lord, on the basis of only co-accused statement, while Raghuram Rauta and Holix Naik were apprehended by the police, while he was in police custody, they have stated that we two of persons, along with the present four petitioners, they were at the spot and they have also made the fire, my Lord. My Lord, the accurate statement I have underlined, my Lord, of Sagar, who was the eyewitness of that, my Lord. Well, I have given the statement, my Lord. Today only I have received that.
Now, how many of you are there? 4, 5.
4. Total 6 number of witness. Total 6 number of accused persons are there. 2 are Holix Naik and Raghuram Rauta, and 4.
What are Mr. Maharaj? What are the other evidences apart from?
My Lord, 147,
Sagar,
148, 149.
apart from Sagar.
Yes, the gravity and the circumstances of the scenario, the crime scenario.
These two persons, Raghuram and
Biswajit Naik,
they were there. There is no doubt about it. Apart from that, what are the other evidences? Because all allegations are against them.
Yes, that it is the charge sheet has been filed. During course of investigation, it is established that, but I'm reading some portions.
Yes.
But
Page number?
Page number 28. Page number 28.
Yes, sir.
Just in the middle person, my Lord, Biswajit, against Biswajit alias Holix. Let's look at it during the time. During the time, against Biswajit and the Holix went to him and with threatening demand the Dada body or else they would harm.
I got
Harm them. However, out of fear over the threatening, the complainant Pradeep Dora has given a cash of rupees 50,000 to Biswajit alias Horlicks. Despite that, Biswajit alias Horlicks used to pick up brawl with complainant on 36/2022 while the operator Vikas alias Sagar was guarding the machine. By the time a group of persons namely Raghunath Raut, Mangala Raut, son of Mangala Raut, then Uttam Swai, son of Sibo Ram Swai,
All these
Oleg
petitions,
Swai, yes,
all
all.
being armed with
All are being armed with cudgel and stick and petrol arrived the spot. When the operator Vikas and Sagar woke up and asked about their coming, they thrust him. Then they, while attempting to kill him by assaulting
all
to his head.
allegations are there. What are
My lord, on the basis of co-accused statement, how these persons can be attributed to this man, my lord? The evidentiary value of co-accused statement under section 162 and it against section 25 of the Evidence Act, it will hit, my lord. They don't have any evidential value.
Then they, while attempting to kill him by assaulting him in the head,
my lord, 307
Tenga and operation. What are the
this?
My lord, where is the injury report? Where is the injury report of section 307, my lord?
No injury report is required in all cases where 307.
No, my lord. There is a specific judgment of state of MP.
What are the recoveries?
Recoveries, but they have only filed the charge sheet. What recovery they have?
What are the other evidences?
My lord, there are no evidences, my lord.
Show me, along with the charge sheet, some 161 statement would have been filed.
My lord, over here, the statement of Vikas, the Sagar, who accused
Sir, I am going. You are seeking indulgence of this court under 482
my lord,
at the cognizance stage.
My lord,
these are the offences and allegations are there against you.
My lord,
show me from 161 statement or other evidences which you are filed, because you have got all the entire paper.
My lord, I have got the entire paper today morning only. I will file it through a memo for the
NBW is pending.
Then comes for the petitioner seeks to file additional document to substantiate his case. He may file the additional document within 1 week. Release the matter. After that. Yes. Next.
My lord, over there, my request, my lord, I have filed a stay proceeding, my lord.
How can I stay? You have not substantiated complete.
My lord, there is an affidavit.
You have attempted to kill. You are armed with so many weapons and all. I don't know.
My lord, I am coming to it, my lord. My lord, there is an affidavit of the informant stating that these persons were not over there due to only political rivalry and on the basis of co-accused statement they are fined, my lord.
I can't.
A notice be issued, my lord. He will be present over here to subsidy of with his.
I don't know in what circumstances the affidavits are obtained.
My lord, they were neither they were present at the spot. Only on the basis of co-accused. What evidences will be there if the investigation
anyway,
is happening,
then I'll simply issue notice.
My lord.
Have you implemented the opposite party? Have you implemented?
No, my lord.
Informant. Then informant will complete or not? You don't file the complete petition.
My lord, he is
the party.
He is the party, my lord. He is the party. I sorry, my lord.
First matter.
OP number 2.
My lord, OP number 2. He is the party, my lord.
Where is that? You say you have not implemented. Where is that?
My lord, I have not seen that, my lord. Big apology, my lord. Pradeep Kumar Dora, OP number 2, my lord. The call statement.
In all the matters?
Yes, my lord.
Okay. Issue notice. Have you implemented? Are you sure?
Yes, my lord.
Yes. Issue notice to opposite party number 2. Written evidence. So. What is the stage? Trial?
My lord, charges has not been framed, my lord.
NBW is pending.
Immediately after vacation, immediately.
My lord, to safeguard their life, my lord, at least till vacation, I need protection, my lord. At least till vacation, my lord. Till the next day.
I can't. If NBW is issued, you tell me, I'll stay.
My lord. That will be all right.
Where is NBW?
My lord, NBW order I have not had expected because I was expecting, to be honest, my lord, I was expecting that I will get an interim order, my lord.
You do one thing. I am sitting on 23rd and 28th.
28th.
Okay? If NBW order is there, you come. I'll stay.
Can I request one thing, my lord? I am requesting, my lord, till vacation. My lord,
you can't. There is no.
My lord, how can they face that? My lord, if in between of that, my lord, if in between of that, my lord.
Get the NBW order, I'll say.
My lord, I am stating.
Say up execution of NBW.
Order should be 9. My lord, order.
Then you are apprehending.
My lord, no, my lord.
I know
I'm saying that, my lord. If in between the vacation, my lord, if a date comes, my lord, then they have to appear, my lord. They will abide the law. For that reason, I am saying, my lord, to safeguard the life till vacation, my lord.
No, I don't know. Anticipatory bail must be rejected.
My lord, no difference will be made if the matter will be taken after vacation, my lord.
Has already been rejected.
Bail anticipatory bail application.
You have not moved. You have not moved. He says that application is rejected.
Bail application. No, my lord.
No, check करनी है तो file check.
Anticipatory bail file ही करना है
then you go and appear. Till then, I'll protect you.
That's what I'm saying, my lord.
Then counsel for the petitions. No, you give that affidavit. Let us speak with that.
My lord.
Then only I can do something. Give that.
You will present at the date concerned. Okay.
Alternate counsel for the petitioner hands up the affidavit of
Informant, my lord. Pradeep Kumar Dora.
Pradeep Kumar Dora. Pradeep Kumar Dora. Due to course of hearing. Affidavit dated? Will be date. 24/12/2020. Date 24/12/2027. 27.
Typographical error. Typographical error.
It's not typographical, seal. Just see the seal. And you have not treated any date. This is the kind of affidavit you file. What to do? Urgent. Yes. Next 30 item.
At 1 p.m.
31. 30.
30.
My lord, date is over here, my lord.
Well,
of affidavit, my lord. 14/5/2020.
but he just see 27. How will I believe all these things?
My lord, it is over there, my lord.
Opposite party number Y.
These are judicial
No,
records.
I understand, my lord.
I can't
Those
take
mistakes
cognizance
have
of
been
an
done by
affidavit.
my associate, my lord. I beg apology for that, my lord. Let it be considered, my lord. I will file under oath commissioner.
And
it
why?
will be replaced by the affidavit with the oath commissioner.
Without filing a petition also, you can come and say that sorry,
No, my-
please
my-
excuse me,
my lord,
pass
I'm
order,
not
I'll file the petition.
My lord, I'm not expecting that liberty, my lord. Only on the basis of if it can be considered.
File a better affidavit 23rd.
My lord.
File a better affidavit 23rd. 28th. No, 23rd.
28. A time.
22. You file it.
30.
Yes.
May I please respond? My lord, I am
Come with proper application, proper affidavit. So that some
My
intelligence.
lord, I understand, my lord, but those have been filed by my associate. It will be taken care of
Whatever
from
you
28, man.
correct it and
I'll recheck it with henceforth in future, my lord, I will check it.
28. Huh?
28.
Madam, I am challenging the order dated 28/2/2023, my lords. My lords, but petition number is the husband, my lords. Petition number, opposite party number 1 is the wife of the present petitioner, my lord. And opposite party number 2 and 3 are the
2 and 3.
my lords.
2 is 19-year-old Elena Sahu.
Anita Sahu is the wife of the present petitioner, my lords.
Ankita.
Anita, my lords. And Elena Sahu and Ankita Sahu is the daughter of the present petitioner, my lords. And my lord, petitioner filed 2 applications. One is the application before the Court of Family Judge Court, Bhubaneswar, and the award is, my lord, 13,000, my lords. The opposite party is directed to 7,000 to the present petition number 1, and 3,000 is to the petition number 2 and 3. 13,000, my lords. And petitioner already paid 13,000, my lords. And thereafter also another filed DV case, my lords. That is, my lord, that is, my lord, London JMFC Bhubaneswar, my lords. And London JMFC Bhubaneswar awarded to the petitioner to pay the amount, but he has not paid, my lord. And
You are agreed by which order?
my lords, I am challenging the order of my lord Sauji. My lord, CMC 524 of 2022, my lords. Order dated, my lords. Order dated, my lord, 28/2/2023, my lord.
Operating part, yes, please.
The petition, my lords, the present petition filed by the aggrieved opposition wife and petition number 2 and 3, 13(1) of Act of Interim Maintenance in terms of monetary relief is hereby allowed party. The respondent number 1 husband is directed to pay 10,000
rupees
per month, my
per
lord.
month to
My
the
lords.
agreed person.
My lords.
And what do you want now?
My lords. But he has also another filed before the Court of Judge Family Court Khordha, and petitioner paid 13,000 to the wife opposite party number 1 and 2 and 3, my lords.
Where is that?
My lords. That is the document.
I have also. I'm searching whatever you are saying. I'm searching everything from
No, my lords.
nothing is there.
List of date of events, my lords.
But show me the order, sir.
My lords, show me orders, my lord. This is the certificate copy, my lords. And Botman, in the meantime, my lord, NBW has issued, my lords.
So show me the NBW. I'll say.
NBW dated, my lords.
That is also not there.
My lords.
That is also not there with you.
No, NBW dated, my lord, 6th May 2024.
Show me the orders. Every order you are keeping in your pocket.
No, my lord, that copy is not with me, my lords. As per my instruction, my lord, lower court advocate, 6th May 2024, my lord.
You file those documents. When comes for the petitioner seeks time to file the petition document. Don't file anything you want indulgence.
My lord, NBW has issued, my lord. Only protected.
You don't have the order. You have the other order which you have that you kept it in your pocket. You have not filed.
My lord. I am challenging the order dated, my lord, Annex 1, that is there, my lord.
That order is if that order is challenged, then I'll dismiss the petition. There is nothing, no illegality.
No, I have.
You say that in another proceeding,
my lords,
13,000 is awarded.
Yes,
so
my lords.
then therefore you give indulgence in this matter. That order is not there in the record.
My lords.
What is this?
That is my lords.
Why are you taking this kind of?
Sorry, my lords. I have also filed.
Oh, adjourn it to July.
23, my lords. I have also.
Next item. 31.
23, my lord.
31.
My lords.
I have obtained instruction.
My lord, I have filed the copy of this, my lord, order along with the NBW.
23 may not be possible. Vacation bench, I don't know, 1,000 matter will be listed. How do I just give indulgence in the harsh cases, but not in this kind of cases.
Petition is a security
No.
guard of the
Then you pay in one court 10,000 and another court 13,000. You keep on paying. Heaven is not going to fall within a month. List it on 20 reopening. 1 month you pay 13,000. How does it make difference?
13,000 I have already paid.
You keep on paying. How does it? This is 10,000. Pay 1 month, 2 months makes no difference. Your liberty is not at stake. Only the matter where the liberty is at stake, I will give the date during the vacation. For maintenance of 10,000 rupees, why should the vacation court will hear? Yes.
In the meantime, interview
Next.
31.
31.
Item 1 will also I had prayed for it.
31 also, my lord.
31?
Item 1.
Yes, item 1.
31, my lords. 31 also Belgium matter, my lords.
Belgium ta kar do Belgium. When
Belgium matter, my lords.
Where is the order?
Na Belgium matter, my lords. Cognizance is taken, my lords. But my lord, kindly last thing.
Where is the NBW order, sir?
NBW order tag is lower court against mention my lords. Say that cognizance challenge my lords. Entire order sheet is filed with my lords.
You say Belgium matter,
Earlier petition was on bail, my lords. Kindly glance. NBW, no. My lord, the accused person is present, other accused person outside. NBW not back with execution, my lords.
Petitioner is agreed by the order dated 14/3/2025, whereby the following order was passed. Accused Trilochan Mohanto is present. Accused Prasanna Patra is absent. Other accused persons are absent. NBW not backed after execution. Remind the OIC concerned to execute the same. Call on 26/4/2025 for production. Then comes for the petitioner submit that he has no clue regarding the no clue as to when the NBW has been issued. NBW has been issued. Therefore, he has challenged the present order. The execution of NBW issued against the petitioner shall be stayed until 30th June 2024, subject to petitioner appealing before the court and availing remedy under law. Very good. Hello.
Pardon, my lord.
Yes, one.
My lord, in item number 29, your lordship has requested the date of 24/12/2027. That is the seal of expiry of the notary, my lord. ଆପଣ ଯୋଉଟା କହିଲେ ଯେ 24/12/2027 ର ଡେଟଟା ଅଛି ସେଟା seal of the expiry.
Item 1 ନେଲା ପରେ pass out. Yes. Yes, item 1 नहीं जो item 1 की नहीं थी ना अमित उड़ा item 1 already order ही थी ना
ना रोहिला गोटे
नहीं अधे order कर दी थी हाँ आपने पता लगा तो dictation दी सर
अधा order है
so अभी now clear.
Also, I am in confused because I could not tested the girl. Because the mental condition, I think she's not well.
To be honest with you, my lord,
very smart way of doing it.
no,
I
my lord,
understand it, but
if my client will not reveal that they have filed an anticipate, I was not the
then they are not entitled for any relief.
My lord, in
They
that
are
case,
not entitled for
my
any
lord, in
relief.
that case, my lord, had it been a case,
My lord. This is what is the statement?
my lord,
What is the statement?
I pray, my lord, till vacation, my lord.
Well, item 32.
Because I could have given it because of two things. That first of all, you said there is no anticipatory bail. Second, after knowing it, you are trying to justify. Then therefore you are
Because,
not.
my lord, I am only justified because I was not having any kind of information. with
Then
that.
your client doesn't.
I admit that, my lord. I admit that, my lord. But my lord, provided on the basis of evidence, if something should be collected, then I don't.
Then again, maritime issuing notice that one.
My lord, after vacation, it will be kept around.
Filed. It will take so long hearing, madam. 108, 109, and 110.
Vacation of stay of what?
They have suspension of conviction, madam. Well, that day, my judgment.
I have already filed my objection along with citations.
True, but it was hearing, madam.
But some court has given.
Say,
that no courtship action.
No good.
Oh.
I have filed for that order to the vacation of that. I have filed that.
On 18th of 19th, I have no objection. But it will take some time, madam, that will take. You will use company. Your last day of the.
No, last day it can't be taken up today.
Last day, madam.
I'll put it immediately after vacation. What? Immediately after vacation. I'll put it.
Vacation.
Immediately after vacation.
My lord,
what happened?
They didn't pass the issue of the election process. What happened in last vacation, now he also. So if you file the application, I don't have it right.
No, my lord, that is not, my lord.
I have just now taken instruction from the IU, my lord. The IU has stated that that matter is going on, my lord. Here, my lord, your lordship stated that expedite as possible without any adjournment. You will not give an adjournment, my lord.
Hearing is going on.
My lord,
today, my lord,
no, my lord. They are telling a completely false. I don't know how they are passing the order. Whether I believe the affidavit of a person or believe the statement of the
This is small thing unless.
small things and the order tag pass kare. No, order picture copy देजी sir और copy देजी affidavit. ता mother mu say they have filed affidavit.
I have just now taken instruction from the IO, my lord, taken instruction from the IO, my lord. He stated that matter is going on. That is my submission, my lord. But this is my lord. But person like my lord, my senior my lord, submitting this type of first day my lord, he stated that there is no such criminal action. My lord, his submission on believing his.
So I am not going into that. You tell me. Otherwise, 4 o'clock, I am passing an order, releasing him and furnishing bond of 50,000 rupees and 2 surety of like amount. Release him. 110 unnecessary. Why unnecessary? Somebody's liberty. You tell me at 4 o'clock if that order is passed, is all right. Otherwise, I am passing an order, releasing him by furnishing bond of 50,000 rupees with 2 surety of like amount. And if you want to arrest him in some other case, arrest him. But it's 110 only. He has to furnish bond and go. For that, why unnecessary? Let him say at 4 o'clock.
My lord, I may be excused, my lord. Item number 109. 108, my lordship was pleased to keep after vacation, immediately after vacation. So for 109 is concerned, it was fixed today for hearing. Connected matter, no.
No.
It's a different matter.
Stay of conviction. I have filed my objection. The same, no courtship.
Same.
Nice.
In this,
Are you asking for no?
Yes, my lord.
There is no order passed.
No.
After vacation.
In this case, the order has not been passed. No, because he is going to retire, no courtship action till reopening date only.
How can you are convicted? Where is the question of suspension of conviction?
Because some decision is before my lordship. There are 4 decisions of this honorable court.
Conviction can't be stayed like
this honorable court has passed.
Cases,
it is exceptional case.
Navjit Singh Sindhu, everybody was relying upon that. That is the judgment.
But it is an exceptional case, my lord.
Then every case is exceptional because everybody.
But here, my lord, only he was taking tuition fees.
The presumption of innocence has already gone.
Yes, my lord. Once he was found convicted, and
then only the sentence is to be suspended. That
only this much.
No question of conviction.
No, my lord. Only suspension of sentence.
Sentence.
My lord. Sentence.
He has been granted bail.
No, sentence of suspension, sentence.
Realization of fine has been. You are getting confused. No, my lord. Two order. One is conviction, another is sentence.
So for sentence,
order which is executable, that is the sentence order, is suspended.
Suspended. No, he has not yet been suspended, man. He has not been suspended. I have made affidavit.
Who has been not suspended?
My lord.
You are thoroughly
Sentence
confused.
has been suspended since 8/1/2024 and he has been granted bail.
Yes. Next.
Maybe pardon to make a mention.
28, yes. Yes.
I have obtained instruction that the case is posted on 22nd Kalikech.
Kalikech. Kalik to आपण लीड कर पे
Reopening रे 18 तारीख
नहीं आओ आगे को ना in vacation there is no vacation for trial court. Criminal courts are not closed. Where is that?
Item
28. Impugn order.
Impugn order at running page 13.
Right now, the petitioner is agreed by the order dated. What is that? 13. Order dated 16/4/2024. Passed by
STGM Jajpur.
STGM Jajpur in
16 case number 119 of 2022.
119 of 2023 under section 138 NDPS. The petitioner's right to lead defense evidence has been closed by the impugn order. The perusal of impugn order indicates that the first time the petitioner was granted opportunity to lead defense evidence on 23/2/2024. Since the petitioner failed to produce defense evidence, the impugn order is passed by closing the defense. Then counsel the petitioner submits that the matter is fixed for final disposal tomorrow. That is in view thereof, the impugn order is set aside, and the trial court is directed to afford a single opportunity to the petitioner to lead the defense evidence on the next date of on a fixed date, on a fixed date to be fixed on a fixed date on a fixed date. It is made clear that the petitioner cannot make adjournment, and he will get only one date of hearing for leading his defense evidence. It is also directed that the petitioner can inform this order to the court below, and once the court below and the court below shall fix the date within fix a date court will to afford an opportunity to the petitioners to leave the defense side. And this observation one day he will leave and lead the evidence, whatever. Yes,
My lords,
21.
maybe
The other side has been directed to file affidavit. And my lord going to, no, they are not yet filed, my lord, and the honorable court has also adjourned the matter to after vacation. Because the honorable court has said once I have passed the order, we passed the order, that come after finalization of all criminal cases, that we have not completed the criminal cases. My lord has ordered.
During faster my lordship was directed that
Sorry?
file an affidavit by if the minor will give the demand.
Then what, how to go about it?
After vacation.
Without any order.
Simply 21, huh?
Okay.
Yes.
32.
They are married by affidavit was the original time and the original affidavit.
363.
That responsibility and why they also filed an affidavit to withdraw the case.
Yes, Mr. Maharaja, just take it up.
164 charge sheet, is there any document? I तो कहना हमें सही ग्राउंड पे कोटा अर्जन नहीं था जो 164 हाँ
Who is the informant in this case? He is not implicated. Ruxana? इधर आओ. इधर आओ. Yes, Mr. Maharaja. Yes.
Sir, I am going through the 164 statement. Just a minute.
Yes. निकानामा देखो. निकानामा.
निकानामा अच्छी.
Recently, 22nd March, they are married.
Where is Nikanama?
They are married. Government is married on 22nd March.
The Nikanama immediately they will give you. What is the problem? Why have you not got? What is the allegation?
Parents were present before this court.
Informant you.
Yes.
Just yes.
ଆପଣ ଯଦିଓ ଭଲ ପାଉଥିଲେ ଯାହା ସହିତ ଯିଏ ଆପଣଙ୍କ ସହିତ ଖରାପ ବ୍ୟବହାର କଲେ ଆପଣ ନିଜ ବିରୁଦ୍ଧରେ ସେ
Acha. Informant, you implead informant. Let a counsel for the petitioners seeks leave of this court to implead the informant in the case and the opposite party number 2. Yes.
उसके साथ आपका सभी हुआ है उसके साथ हुआ जो गलत किया था उसके साथ हुआ तो समझ में आ रहा है जो गलत किया था वो उसके साथ हुआ ठीक है वही समझ आपको
SL जी
कोई बात नहीं फर्स्ट implead. Yes. Yes, I know. At the instance of opposite party number 3. Now implead opposite party number 3. Informant. 3. Informant. Newly implemented opposite party number 3. FIR number so and so came to the petition.
charge sheet and 164 statement the victim can be taken on record.
The after investigation charge sheet was filed. Charge sheet was filed in the when the charge sheet was filed. Charge sheet was filed before the it has already been committed.
Commitment is
Commitment.
commitment is
POCSO court file it, na? Right. Before the trial could start, the petitioner parties the then counsel for the petitioners charge sheet date charge sheet was filed on for offense under section 363, 376 2N, 366 and section 6 of post. Copy of charge sheet and recorded statement of the victim recorded under 160 is taken out of the parties stated to have settled the issue. Petitioner and opposite party petitioners. How many petitioners are there? Petitioner and opposite party number 2 and 3 are present in the court. They are being represented by the respective counsel and identified by them. And they file the separate copy of their affidavit. Other than which are taken on the court. The petitioner and opposite parties 2 and 3 have 2 and 3. Where is 3 of affidavit? Opposite party 3 the affidavit right? He is the informant. Don't shall I educate you on this? Informant has to file affidavit. He is the person. He is the minor. What is the meaning of that affidavit? Who has initiated the criminal case against you? If you are settled, with whom you will settle? And complainant will not file affidavit. These primary things I can't tell also. Right on. Get the affidavit. Patapat. Right on. Shall I write that you are filing the affidavit? Then petitioner, opposite party number 2 and 3 have filed separate affidavit dated as it did. Entry as stating as under. Para 2 days. Para 2 days. Okay. The petitioner has also filed separate affidavit dated so also reiterating the same step. The affidavits are taken under court. And don't upload unless the affidavit is given. The parties Mr. Maharaja appeared for the state and submit that since the parties have settled their dispute at petition number 1 has married to opposite party number 2 on 22 when marriage is taken place 22 March 2022 and they are residing as wife and husband so as to say the happy marriage life of the petitioner and opposite party number 2. The court there is no legal impediment. There is no legal impediment in passing the FIR in view of the law laid down by this court in Rosalie. Although the party, although petitioner number 1 and 4, petitioner and opposite party number 2 have already made it on 22nd March 2024, and in the affidavit filed before the court, they have admitted this fact, but no nikanama has been placed on record. No nikanama is placed on record. Who the parents of continue. No place on the product. The parents of the victim and the petitioner are also present in the court, and they are conjointly state that the party, the petitioner has already married with the opposite party number 2. Taking into consideration the fact that the petitioner and opposite party number 2 have already married, and the fact that the family of both the petitioner and opposite party have accepted the marriage, and to save the marital life of the opposite party number 2, I'm inclined to entertain this petition. Next, in view of the law laid down by this court in Rosalind, and the law laid down by the Honorable Supreme Court in Gyan Singh and P.C. Joshi, the petition declares marriage, subject to the petitioner's trial with the futile exercise that was quashed. Affidavit given are signed. Yes.
34.
Yes. Offense? Injury report. Show me. Injury. Huh? Maybe injured. Who is injured?
Today's Whereas I have one more objection also. If your lordship sees page 10, the FIR, there are other victims also. Hiranya Rana, Bhaktaram Rana, and
You have to implead all the
Vikas
injured.
Rana. All of them have to be impleaded.
You have not impleaded injured. Let the counsel or the petitioner seek leave of this court to implead all the injured person in the present case. He may do so within a week. Release the matter of law. Yes. Next.
41. Well, may I call for the injury report?
Injury report, get the injury report.
I'll get the injury report.
What kind of, maybe simple injury?
Your lordship.
You implead that.
Simple injury.
And if you have injury report, you place it on the court. They will get it. Mr. Arnav Behra, appearing for the state, shall produce before the court the injury report by next year. Yes.
Item 40.
40.
Yes.
Item 39, lordships.
Let's say 9 years of dispute between minor to co-villagers minor. So 9 years has been settled. 307 along with other offences of their minor. There are both are present before this.
Where is the injury report?
I have supplied the injury. Injury simple.
Who injured? Injured ke? How ke injured? He is the informant and injured. There is injured report. Where is the injury report?
Simple injury, madam.
Simple.
Simple.
Yes. Very vital part. Tattoo photo को डाला रहता है ସେଥିପାଇଁ ଟାଟୁ କରିଦେବି
ତାରି ଉପରେ ଟାଟୁ
charge sheet filed
Charge
sheet filed on
data ko FIR is charge sheet.
You won't be surprised someday they will send a slip. Please quash the FIR. High Court. This is what is happening here. He doesn't know whether charge sheet is filed. 2 pages FIR, quash. Nothing. Nothing is filed. No injury report, nothing. Offense is 307. What is this going on? I don't understand. These are minimum thing whether the case is at investigating stage or charge sheet is filed. Give me the date. What is the stage you tell me?
His charge sheet has been filed, my lord. Trial has not been started.
आप कॉपी है ना अभी?
ଗୋଟେ କପି ଆଣିଛନ୍ତି ଇଞ୍ଜୁରି ରିପୋର୍ଟ କପିଟା ଆଣିଛନ୍ତି ସେ ଗୋଟେ ସିଙ୍ଗଲ କପି ଆଉ କପି ନାହିଁ
Very poor. Thank you very much that you have filed a petition.
For that reason, my lord, yesterday one judgment of Honorable Appeals Court, my lord, in comparison matter, in that case, my lord, the Honorable Appeals Court sent the, my lord, the affidavit to the concerned police station for verified genuineness.
What to do if this kind of petition?
For that reason, my lord, we have to send, my lord, whether the matter is compromised or not, my lord.
And see, then we are increasing the work of police also unnecessarily.
Otherwise, my lord,
these people are filing petition without any particular, without including the injured also, without including the
here, one paragraph read out, my lord. State has filed the compliance affidavit shown by the sub-inspector of police station concerned who is verified that fact that the appellant and the complainant have a solemnized marriage with each other. So thereafter the case is compromised.
The victim is the injured.
What is the stage of the investigation or when the charge sheet is filed, cognizance is taken or not, when the cognizance is taken, whether charge is framed or not, you know nothing. You know nothing. How do you expect that I should pass the FIR?
23rd को आसी instruction.
I have to record it. What is the stage, whether charge is framed or not?
Yes.
पता चला पास कर दी पता चला सीट कन्विक्शन ही जाती
kindly participate matter I will look at it.
कुछ भी नहीं. There is nothing, not a single whisper about what has happened.
Yes, my lord.
What is the allegation? Nothing is there. See, FIR, you can't read it.
That's what
But may I pray, if your lordships may keep it on 28th, then let me produce the injury report. Then the authenticity will be without doubt.
The copy of the
See, a 482 petition is filed on his behalf, saying that it is settled. It is his responsibility to at least file a petition properly.
Yes, ma'am.
If you don't file, why indulgence by the court?
But because this
why the police machinery will work from them? After all, they are accused.
But this injury report also has to be
committed an offence against the state.
Cannot be produced
307.
like that.
Why should the court will be lenient on you? Why should the state machinery will work for you? Reason it to after vacation.
28th I will produce also.
28, I don't know how many matters will be listed. Vacation, there will be 100 of 100 matters.
One passover I will.
You get it. If you file proper petition, if you want indulgence, don't do that.
Yes.
Yes.
Kindly passover.
41.
Item 41, my lord. Compromise matter, lordship. And my lord, I pray lordship next as for lordship, my lord also, I got
I can't hear you. I can't hear you.
Lordship, I pray my lord, lordship, I produce the
20, it may not be possible, sir. I don't know how many matters will be.
petitioners are present before your lordship, but due to not obtaining the injury report, lordship, I pray only.
The same thing here also you have filed, except affidavit, FIR.
I pray lordship, lordship, I have already applied the certificate.
There is nothing except a 2-page FIR which nobody can read.
As for your lordship,
Next.
44.
This process where unnecessary wasting time. Unnecessary wasting time. So वो ना वो 28 में तो किसी कौन छुट्टी करो unnecessary slow मजाक होने की.
Local election, there was a dispute between two groups. In the meantime, the matter has been settled. The injured, including the informant, are also present. Now the stage is investigation. Soon after the incident, they have approved the.
You have filed 2 FIR. Which FIR?
Annexure 1.
What is the second FIR?
Second FIR, case and counter case.
What is the stage of the
investigation is now going on.
Right here.
Soon after the incident, they have approached the police to withdraw both the FIR, but the police did not act upon, rather.
What are the offences?
307 is there and Arms Act is also there. 307 is there and Arms Act is also there.
All are injured, including the informant. They have settled their dispute.
They might have settled. What are the injuries? Injury reports show me.
Injury report is not with us, but the injured have.
307 Arms Act.
Injured have stated that simple injury. There was a tussle between both the.
Injury. The injured is a doctor.
Tussle.
Injured is a doctor. How has he said that it is simple or grievous?
They have stated that there are some simple.
He might have said, but show me investigation is on. Show me the medical document that it is a simple injury. Then I can give intelligence. That's the problem. You don't file except FIR, nothing.
FIR and the affidavit they have. And now the police is trying to arrest the petitioners. For that reason,
that's another
no
problem.
Record may be called for.
What is the stage of investigation?
But still, the investigation is going on, so therefore we can't say. I'll call for the case diary, madam.
Call for case diary. First day I can't do it because see the petition. Petition. Nothing is said.
In the affidavit, the injured have stated that during the course of tussle, they have suffered some simple injury.
That's what I'm asking. The injured is a doctor or what?
No.
How has he opined that it is a simple injury? Doctor has to tell that. The day when the incident had taken place, he might have been taken to the hospital. Call for diary.
I'll call for case.
I have made a mistake. IO has made a prayer to response of NDPS.
So show me the NBW. I'll say.
Madam. In the I have annexed the document.
Item 42, na? Item 44. 44. Where have you said that in IA? NBW issue?
Running page, para 4. It is respectfully submitted here that after lodging of the FIR and during the course of investigation, the IO of the case made a prayer.
The petitioner is seeking quashing of FIR number first FIR. Next one, FIR 2 on the ground of settlement. Investigation of the case is still going. The accused persons, all the accused persons, all 9 accused persons, all the 9 accused persons, and the opposite party number 2, who is injured, and who is injured? Informant, opposite party. Opposite.
Jitendra Behra,
1 minute.
Behra and Sibo Sankar.
All the 9 accused persons are present in the court, being represented by their counsel, and I will be opposite party number 2 to 5 are also present.
2, 3, 4, 5.
It is stated that opposite party number 2 is the informant in the present case, whereas opposite party number 3, 4, 5 are the injured. In the present petition, except the FIR, no document is included. To ascertain whether the injured injury sustained by opposite party number 3 to 5 are grievous or simple or grievous illness. Therefore, issue notice to the state. Proceeding call. In the higher LQ, then counsel for the petitioner submits that the parties have settled their issue and they filed the affidavit, joint affidavit before this court, inter alia stating that they have settled the dispute and the opposite party number 2 to 5 are not interested to prosecute the petitioner. The affidavit is taken on record. And then counsel for the petitioner hands up for the certified copy of the order dated 15/5/2024, wherein on the request of the IO, NBW has been issued against the petitioner. Since the matter has already been settled, and notice has been issued to the state for production of the CD. The execution of NBW issued against the petitioner by the order dated 15/5/2024 is state till next date of the day.
Is your lordship is posting it to?
Posting it to immediately after the case.
No coercive action.
I am saying the NBW what no coercive action. Yes. Next.
Regular. 33.
This is there for compromise, my lord.
Compromise.
Your lordship may issue notice.
What is the FIR is? 294, 330. Okay. Issue notice. 33.
Sorry, my lord.
Simply issue notice. Okay. Next. Yes.
35.
May I please, your lordship? My lord, I am challenging the order under Annexure 1 passed by the Law and Special Judge Vigilance Balangi. Annexure 1, where 294 CRPC petition filed by the prosecution has been allowed. My lord, 294 says that without formal proof, a document can be admitted into evidence. And here the chemical examination report, which should have been allowed either proved through the IO or the maker of the document himself, but it has been admitted into evidence when the maker of the chemical examination report has been cited at charge sheet witness number 15, my lord, as page 25. So without deposing, now the defense is totally prejudiced, but how can I dispute the genuineness of that document and I have no chance to cross-examine the maker of the document?
You recall that. Recall
no, it is the prosecution who has to bring that witness. It is their witness. They have cited it in charge sheet. Your lordship may kindly see.
This document is introduced after the examination of that witness.
No, my lord.
PW 17.
No, my lord.
Yes.
He has not deposed before the court. He has not been called upon to depose before the court.
Show me the impugned order.
Impugned order is on
page 10. Page 10.
Page 10.
Yes.
And the Honorable Supreme Court also, my lord, directly said that if the genuineness is, my lord, disputed, you cannot.
First read the impugned order, thereafter we will go to Supreme Court.
My lord, page 9, my lord, Annexure 1.
Yes.
There is the record from second para, my lord.
Yes.
Though the C report of the chemical examiner is available in the record, but the same is not exhibited into evidence. It is contended by the learned special PP that the IO of this case who received the chemical examination report would prove the C report, but he having died, the same could not be exhibited. The learned special PP though filed the petition under section 294 of the CRPC under erroneous belief, but in real sense the prayer made by the special PP attacks the provision of section 293 CRPC, which says that any document purporting to be a report under the hand of a government scientific expert to whom this concept applies upon any matter or thing duly submitted to him for examination or analysis and report in the course of any proceeding under this code may be used as evidence in any inquiry, trial or other proceeding under the code. This is a case of the year 2018. In this case, 5 witnesses have already been examined, including TLO. The objection raised by the Line and Defense Counsel to the aforesaid petition appears to be superficial and merely intended to protect the litigation. No material is brought before the court to arrive at a conclusion that the examination of the chemical examiner is essential, otherwise the defense will be prejudiced. My lord, with great respect, my lord, when the IO examined, they did not exhibit. They themselves have not cited the.
That was there on record, and the witness have died.
Not died. He has not been. The IO has also not deposed me.
But he died. That's what the.
Therefore, my lord, therefore the maker of the chemical examination report, who is very much available, who is alive, and your lordship may kindly see page 25 now. Page 25, the charge sheet witnesses list in 15, serial number 15. He has been cited as charge sheet witness number 15 by the prosecution.
Right.
Hemant Kumar Pradhan, Assistant Chemical Examiner, Deputy Director, RFSL, Sambhalpur, will prove the chemical examination report. So, without calling him and without giving the defense the chance to cross-examine him, when the accused persons may not seriously dispute the genuineness of the report, how can it be admitted? Its contents can be admitted.
Yes.
And here, my lord, direct decisions, my lord, of the Honorable Supreme Court and our Honorable High Court, my lord.
Yes.
And handwriting expert report was admitted into evidence. Supreme Court said it cannot be when the genuineness is under challenge.
Which para?
My lord. Para.
Kesav Datta.
My lord.
Which para?
Alert para 13. In the instant case, it is only the report of the handwriting expert, XPY, which connects the appellant with the offense on account of XPR, which is said to be in his handwriting. Since the appellant had neither received the money nor has he present spot where the accused were apprehended, his case is to be treated on a different footing, and since his complicity has not been established beyond doubt, he must be given the benefit of doubt.
Next.
And my lord, 93(6) social, my lord, your lordship may kindly see.
Which
94 and 311, my lord. If the genuineness is disputed.
Which paragraph?
My lord, paragraph 7 and 8, my lord.
Yes. That was an application under 311.
311 to recall the witness, but here not the witness himself is not examined, not deposed. But the prosecution itself relies on that witness to prove it true.
That witness died.
No.
That is what is there.
He is eligible, my lord. IO has died. Chairman, my lord, the prosecution wants to say that we will not examine the IO since he is dead. We will also not examine the maker of the chemical examination report, who is Ali. And we will not take, it will be admitted into evidence without giving defense a chance to rebut or cross-examine.
Yes, you have cited that witness and
witness. Thing is that we have not examined him.
Yes.
So the document itself is supposed to be exhibited by the IU through IU. IU is dead. IU is dead.
Yes.
It is a public document, and it was exhibited on objection. If suppose he has an objection, he has to file a petition to recall that. Suppose we have not
he has objected to it.
Objected to it. So he has to, on the genuine counter of genuineness. So far as genuineness is concerned, he has every right to examine. So he has to file a petition before the court below for calling of the PWC 15.
That's what I'm.
Instead of doing that, he cannot challenge this order.
You can move an application at 311 to confront that.
With great respect, my lord, I do not want, my lord, to prolong. Your lordship may say the prosecution to produce that CS witness number 15.
Application
by the impure order.
If he denies, with great respect, my lord, he is a prosecution witness cited by the prosecution himself.
You cannot call him. You can also file a petition.
The prosecution to
we are not examining.
Not preclude you to call for that witness.
My lord, how can I call for that witness? My lord, entire system will be topsy-turvy. They say we want to. They want to convict.
Yeah, you don't want to examine.
We don't want to examine him because it's a public document. So law is also well settled that since it's a public document.
Your lordship may kindly see, even post-mortem report, Honorable High Court has said it is not a public document because the defense can ask whether the injury you have cited, it is by fall or it is by war, whether it is homicidal, it is suicidal.
So far as genuineness is concerned, he has every right, even if it is a public document, he has every right to examine. Suppose we are not examining the witness, examiner, he can file a petition in appropriate stage and he will be called.
The honors will be on defense, my lord. With great respect, it is not my document. It is your document.
So it's a public document. Why should we prove it?
You have objected to it. The objection is taken on record.
With great respect, my lord, how can a document without the IO or the maker, when they are elite,
the IO has died? That's the whole difficulty.
There is nothing on record that CS witness number 15 is not there.
What is the stage of the trial?
Trial is, my lord, prosecution, they are examining witnesses, my lord. Now,
why have you chosen not to? How do you know that the prosecutor has chosen not to examine this witness?
No, we are not saying if we are suppose we are cited him an witness, we don't want to examine him. They cannot compel us to examine us.
No,
if he is agreed.
You are making that statement. I'll record it. Shall I record it that you don't want to examine?
We don't want to examine it. The so far record shows he has not been examined.
Where does it say that you do?
He has not even examined.
Not so far you have not
Examined. That
You may be
stage has,
examined.
my submission is that stage has not arise. We may call him.
So that's what.
If that stage is not arrived, how can
Shall I record it and dispose it?
With great respect,
It can be disposed of. What I am suggesting.
With great respect, my lord.
See, you are only grievance today.
I want to cross-examine the maker of the document.
Maker of the document.
lord.
Maker of document is cited as one of the witness.
By the
witness.
prosecution.
And neither you know nor he knows whether that witness will be called by petitioner. If they don't call, then the situation is different.
With that liberty, it may be disposed.
He is cited witness. Why are you presuming that he will not call?
A simple question I pose to myself. How a postmortem report even can be admitted into evidence? Its contents.
I am asking something else. Don't go
With
to.
great respect.
I am saying, in so far as that particular cited witness is concerned, you don't know whether he will call or not. And according to me, it is now premature. They may call that witness to examine. Then you have an opportunity to have recorded your objection to that.
Great respect, my lord. It will be admitted into evidence when that witness will come to the witness box and say that I have prepared this.
But you have right to cross-examine.
Cross-examine him. So, your lordship, direct the Lorraine trial court to issue summon to this witness.
And I can't control the prosecution. If they don't do it, then you come to this court. I can't control the prosecution. I can't advise them to examine X, Y, Z. They don't examine. Don't examine.
Or can set aside the impugned order. Thereafter, they will.
How can you? What is wrong in the impugned order? It is exhibited an objection.
I'll protect your interest and pass balance order.
With great respect, my lord. It's a typical trap case where the prosecution said that the accused number 2 has received the money on behalf of the accused number 1, and the chemical examination report is one of the basis on the basis of which they want to convict me. And now they say either the IO cannot be called because he is dead. We will also not call the maker of the document, and its contents will be admitted. On the basis of that, we will be convicted when he is elite, my lord, and cited as a witness. Entire thing will be topsy-turvy. You rely on the chemical examination report. So it is onus is on to prove that they are like the prosecution. This is the postmortem report. Either you exhibit it through the doctor, and the defense is granted a chance to cross-examine him.
Why are you saying so much? Your case is simple, one line.
Hello.
Why are you going here and there?
Hello.
You say a document was brought on record. I have objected to it. And that document can only be proved through a witness which has been cited. They are not examining that person.
Right.
You don't know whether they will examine it or not. Wait for the day. They may call that witness.
Now,
how do you know?
Now, what they have
you show me from the record that they have said that we will not examine
but
it.
Now, my lord, now they have, my lord, closed their evidence, and now the case is posted for accused.
Show me where they have closed it. Show me from the record.
ସେଇଟା ତ କହୁନାହାନ୍ତି
Going here, then ପୃଥିବୀ ଚାରିଆଡେ ପଳେଇଲେଣି ଗୋଟେ ଜିନିଷକୁ ଦେଖୁନ
ସେଇଟା ତ କହିଲେ you can file a petition there he will be called.
You show me if they close the evidence. ଏପଟେ ବୁଲୁଛନ୍ତି
16 for 2004 for hearing, but he has not stated, but I have taken.
Sir, you just show me that the prosecution evidence has been closed. If it is closed, then we will come to the conclusion that the cited witness has not been examined, despite the fact that I have objected to this document. How that document can go on record?
Well, your lordship, kindly record my instruction that he has not stated. Para 10, he should have, because next date, my lord, they have filed the closure memo, and now.
ଆମେ କଣ କରିବୁ ଆପଣ ଏବେଠୁ କହିଲେ କେମିତି ହବ? ଯଦି କରୁ ସେପଟେ you have a stage. You have a stage to examine.
My lord, now they have closed their evidence.
Show me, sir, where they have closed.
That has not been stated by the learned judge, but as per my instruction by the.
I will not go by instruction. Either you show me the proceeding, or you.
I will file the order sheet. Your lordship may kindly keep it to after the vacation any date.
Come to that. That's the best way of doing it.
Kindly stay the proceeding, my lord. I will be prejudiced.
Proceeding can stay over.
Kindly, my lord. Up to
No, there is no.
I tell you one thing. They may call and then if I stay. The witness you want that they should call, they can't call. I will not say. They may call the same witness which you want.
But it is closed.
Why should I stay?
It is closed from their side.
No. You are not showing anything. Why should I go? What is this? The only thing we are supposed to bring on record that you have not brought on.
May I suggest one thing, my lord?
Yes.
Your lordship may dispose of with a observation that if evidence will be closed, he will keep without examining him because he has been cited in the objection with objection.
Fair idea.
With objection, it has the
See,
genuineness can be tested.
What
He
he
can call
says
him.
is, I'll
They file a
dispose it
petition, it will be considered.
in the event they have closed the evidence without recording that cited witness, you have cause of action to challenge this.
Yes, my lord.
To revive your petition.
But he will be called on behalf of the defense.
Court depends upon you will file a petition, court will call him, summon him.
But your lordship, kindly, with that observation, I will file a petition and the court may call him. EW.
ସେଇଟା ତ ମୁଁ ଆରମ୍ଭରୁ କହୁଛି ଆପଣ କାଇଁ ସମୟ
Let the counsel for the petitioner petitioner is agreed by the order dated 10/4/2024, whereby the application moved by the prosecution under section of 293.
294.
293. That is actually 293. 293 CRPC has been allowed. And which document? The what?
Chemical examination.
Chemical examination report has been taken on record. The defense has objected to the said document.
Genuineness of the document.
Genuineness of the said document. The land counsel or the petition submits that who is the author? The author of the examination.
Hemanta Kumar Pradhan.
PW 15. PW 15.
The author of the examination.
The examiner.
Chemical examination report is cited as the witness in the charge sheet being
PW 15.
witness number 50. 50. He has an apprehension that the prosecution would be dropping that witness. On oral instruction, the counsel for the petitioner submits that the prosecution has already closed their evidence. However, nothing is placed on record to substantiate the same. Therefore, the grievance of the petitioner is confined to the fact that the witness number 15 cited in the charge sheet has been dropped by the prosecution. I'm not inclined to interpret in the review order at this stage. However, liberty is granted to the petitioner to move appropriate application before the court below. In this regard, and if such application is moved, same shall be considered on its own merit. Dismissal. Yes.
Then he may be summoned. Otherwise, again, I have to oppose. It will elongate also. One day will come, I will cross-examine.
Can a court direct the prosecution to examine a particular witness? Answer yes or no.
No, madam.
Then why are you asking? This is the court of exercising 482. I can't give a direction. Examine this witness or that witness. That is their prerogative. If they don't examine, then you get the advantage of that. If they examine, if you are still agreed, liberty is already granted to you, you can come. That liberty I have given. You move application.
Till then, the trial may not proceed.
What
are you asking? You don't understand the implication. Next slide. 36.
Passing of the entire criminal proceeding on the ground of compromise are only the both parties are present inside this honorable.
And the other victims have not been made parties. Only informant.
Victims 307 victim is not made party. No, who is the victim?
If your lordship sees page 24, there is
also but other victims.
Rashmi Ranjan Behra, Neela Chakra Behra, Dr. Rana Behra, and Jagabandhu Behra. Jagabandhu Behra has been made a party.
You have beaten so many people. Where are the others? Then
already prosecution has started and the other victim is amicably settled both parties.
You would make them party in this proceeding. You would make them a party.
They are fighting the trial. The trial is going on.
Why should it be postponed?
Amicably settled both the parties. But 324 is not compatible. So.
You will be acquitted. You will be acquitted. Why are you asking for quashing? Which paragraph? They are saying everything against you.
Lastly, it is stated that the amicable should not proceed the case in future.
But in the examination chief, they say that you have beaten using Katuri and all everything. That the evidence is against you.
Wastage of time is one family member.
No, wastage, I am not on the wastage of time. The evidence which you are filing, all are against you.
Lastly, all the victims are stated to amicably settle the matter and not proceed in future.
Where? Which?
So page 3, informant is stated for cross-examination, further cross-examination.
Very interesting. The witnesses have said everything against the accused. Cross-examined and everything has happened. Thereafter, the witnesses were recalled. And in the recall, only one sentence he said that we have settled the issue. How will you get to this evidence which has come on record? How will you get through this evidence? On cross-examination and the examination chief, minute detail, how you have attacked, how you have beaten, everything is stated by the witnesses. And in recall, one sentence, we have amicably settled the issue. And then the other witness evidences will be washed away because of this.
Other evidence already closed before this below.
Very difficult.
Madam,
You implead them. Implead them. By that time, I think you will be convicted also. That you know that you will be convicted because of the kind of evidence which has come on record. That's the reason you went and settled with them. And now you are filing this.
One related family member.
Whatever, that's the fact. The evidence has come on records. On the basis of this evidence, you are bound to be convicted under 307. Implead the person. Then consider petition seeks to seek legal of this court to implead implead the injury. 1 week adjourn after the case. Yes. 37. Yes, sir.
This is challenging the order dated 8/2023, the order taking cognizance of my lord, 420, 294, 460, 506, and 4 by this my lord.
Yes.
What is happened, my lord? Case granted to complaint case. The complainant tells that the complainant was applied for the RRB for local pilot.
No, this is the FIR.
Here is the complaint case, my lord.
Where is the complaint? This is the FIR.
Alex, one, my lord, says 10.
It is 1cc case, no?
1cc case.
156.3. Okay. Yes.
That complainant was applied for RRB for local pilot. Thereafter, that shortlisted, then appealed. Then the grandfather of the complainant, Srikanta Samanto, is contact to the one Padmalochana, to another person. Thereafter, the 3 person contact to the present petitioner to engage the railway service. Where the present, the younger brother of the present petitioner was serving the railway.
Thereafter, the alleged there, the present petitioner along with the other person come to the house of the complainant and took money 2,60,000. Now, the present.
They promised to give the job.
My lord, my present petitioner is a 100% blind man. And kind of Alexa for my 100% blind. But the other person are not charge sheeted man. Only the present petitioner is charge sheeted man. ଅନ୍ଧ ଲୋକ କେତେ ପଇସା ସେ ଆଣିଲା ସିଏ ଜାଣିନି ଯିଏ ଲୋକ ତାଙ୍କ ସାଙ୍ଗରେ ଗଲେ ସେମାନେ prosecution could not prove the charge. Charge sheet is submitted, my lord.
Yes.
The charge sheet.
Let me call for the 160. Let the 161 statements be produced.
But she is a blind man.
Well, merely because that does not mean that he cannot commit a crime.
That's right, but God has already penalized him too much. I'll stay.
Your Lordship, please. But let the evidences be produced.
Hard case. Maybe 2 lakh rupees he might have taken, I don't know. But she's a blind. Issue notice and stay. We'll see. Huh? Issue notice. Huh? Where is that order?
32.
32.
23, 9, 20, my lord.
32.
My lord, says 32.
Order dated?
Order dated 23, 9, 2020.
23, 9. Okay. I'll stay the execution of the warrant and issue notice. Issue notice, returnable so. In the meantime, the execution of NBW issued against the petitioner by the order dated 23/9/2020 by the court of which court? By the ACGM Paleswar in city case number 787 of 2019. This day. I've stayed NBW, go on, nothing. We'll see. We'll see. Bring.
Your Lordship may also say that the petitioner will file additional documents, the Section 161 statements and other evidence.
Petitioner is also seeking a leave of this court to place on record the additional document. He may do so by next chapter. 38.
Now, the petitioner, Lordship, is the member of this bar matter. Mr. 4, page 37. The High Court, the allegation that some of the persons have blocked the road and the police is the informant in this case. And absolutely no offense is affected against the petitioner. Only the police person who has lost the affair said that these persons are present. That is the last 3 lines. And the 161, all the 161 statement I have also annexed. None of this says that the petitioner have done anything in the road. Rather on that he is in the court matter as the police have a tussle with the at that time. So they are picking up the putting in the case matter.
Let us see the you are challenging the cognizance order. Let us see the charge sheet. What are they?
The charge sheet under section, my lord. 341.
Forget about section. You tell me the factually what are the allegations.
The affair is under annexure 1, my lord.
I am talking about charge sheet.
The charge sheet is there.
Come to 27, page 27. Read it. What are the allegations?
This case was filed that on 29/1/2018 at 11:30 AM, complainant of Kishore Paharaj, ASI of Police Vidana CPS, Patak UPD, present a written report alleging therein that on 29/1/2018 at about 9 AM, we received a telephonic information. Some persons of Siddheshwar Sai under Lalbagh PS have made Rasta road on the middle of the road near Sony Motors in the between Kanika Chowk and Central Chowk by setting fire by means of tires. He along with PS staff left for the spot to verify the information and he found some persons had blocked the public road near Sony Motors. The traffic was completely paralyzed on spot. The passers-by with their vehicles were found in both sides of the road, which was causing inconvenience to the general public. On being asked, they told him that they are protesting against the inaction of CMC authority in connection with logging of drainage water on their Siddheshwar Sai Kalani road, leading to Siddheshwar Sai. In spite of which sincere request and frustration, they did not.
Yes.
And all the 161 statements name.
Yes, what is
all the 161 statements name
it. Single line against me.
It is there.
That
No,
CMC came forward.
That is there. See, you are the local leaders.
I am a lawyer, my lord. I am practicing here on that day also. I have appeared in this case, my lord. They are only picking the lawyer at that time, the 2018-19 case will also remind at that time.
Framers of the
lawyers
Constitution, our first Prime Minister, all of them have been lawyers.
Here Lordship has to take into care of it, my lord. What is
He
the offense he has committed?
is making a good leader now by doing all these things.
What is the offense, my lord? Yes.
In this process only he will be the minister now. Local leaders.
431, 186, 341. And there is no one in the victimized whether he has stopped.
How many accused?
4 accused persons are there, man. I have already given entire charge sheet, man. Absolutely no material, my lord, to attract the.
Just see 161.
All of them name him. Your Lordship will see.
Only last line. Only last line, 7%.
Last 4 lines, all their names are there.
Never.
Over the page, there's a
no act is there. What he has done.
You blocked the road and didn't allow the public to cross through that road. Burn something in the road.
And it is the CMC, while the CMC come and they withdraw from there. After CMC clear the water loggage, thereafter the withdraw.
Your Lordship will see the second statement, Soilendu Sahu. My brief is not paginate.
Soilendu Sahu, yes.
Your Lordship will see the last 4 lines. ମୁଁ ଜାଣିବାକୁ ପାଇଲି ଯେ ସିଦ୍ଧେଶ୍ୱର ସାହିରେ ବିପର୍ଯ୍ୟସ୍ତ ପରିମଳ ବ୍ୟବସ୍ଥା ତଥା ଡ୍ରେନେଜ ବ୍ୟବସ୍ଥାକୁ ନେଇ ତଥା ସିଏମସି କର୍ତ୍ତୃପକ୍ଷଙ୍କ ସିଦ୍ଧେଶ୍ୱର ସାହି ବାସିନ୍ଦାଙ୍କ ପ୍ରତି ଅବହେଳା ଯୋଗୁଁ ପ୍ରତିବାଦ ଜଣାଇ ସିଦ୍ଧେଶ୍ୱର ସାହିର ମଧୁମିତା ରାୟ
ମୁଁ ଜାଣିବାକୁ ପାଇଲି କାଠୁ
ସୂର୍ଯ୍ୟ ଦାସ
କାଠୁ ଜାଣିବାକୁ ପାଇଲି
ରାସ୍ତା ଉପରେ ଟାୟାର ଜାଳି ସୋନି ମୋଟର ସାମ୍ନାରେ
Has he seen any witness?
No witness. All
eyewitness.
ସବୁ ଜାଣିବାକୁ ପାଇଲି 4ଟା ସାକ୍ଷୀ ଯୋଉ ଦେଇଛନ୍ତି ଖାଲି ଜାଣିବାକୁ ପାଇଲି no victim is there.
Crowd ଭିତରେ କିଏ ଆସିଲା କଣ କଲା who knows?
they have all said ମୁଁ ଜାଣିବାକୁ ପାଇଲି
ସମସ୍ତେ ତ ଜାଣିବାକୁ
all hearsay.
all hearsay.
And issue notice, sir. Issue notice, returnable examine a small offense,
small offense,
and a lawyer. You are on bail.
Yes, I have already appeared, and
then you don't need any protection. Issue notice,
stay of proceeding.
If I'll say the proceeding, then the other people will also get benefit. Slowly 9 petition will come.
Okay, next
reopening. 39. Just see if any other evidence is there, all right. Otherwise, on the basis of hearsay evidence, why should he suffer the trial? Nobody has seen him doing anything. Nobody seen. 39.
Lordships, with your permission, I am appearing to the virtual mode, Lordships.
Sorry?
I'm on virtual mode, Lordships, with your leave.
Yes.
I filed an application seeking quashing of the FIR at page 25, Lordships. Sorry, page 23, Lordships. See, I am the maternal uncle of the husband. My only crime is that I am the maternal uncle. The marriage was solemnized in 2017, Lordships. Then the lady, respondent number 2. Then
what are the allegations against you?
Allegation, there are 2 allegations as I could make out from the FIR, that I was part of the 3 persons of the family that assaulted her. That is one allegation. The second is that the husband demanded 20 lakhs and he took it to his own account and also gave it to my account. And no date, nothing mentioned in the FIR, then that is lodged in 2022. The marriage occurred, Lordship, in 2017.
The dowry demand which has been made by the husband is taken by part of the dowry amount is taken by you in your account.
She says that 20 lakhs was taken by the husband from her father to his account and also to my account. That I have never taken. I was never there. I was in Patamundai. The incident occurred in Kendrapada. I never have visited their house. Leave alone my visiting to that place, Lordships. There was a restriction of conjugal rights by the husband. She declined to join.
Seems like a proper matrimonial dispute.
Issue notice. Issue notice.
My lords,
is there a chance of settlement? What about the other husband and all? Have they initiated any?
There is a divorce proceeding initiated by the husband, my lords, which is pending. Charge sheet has not been filed, my lords, since last 2 years. My lords, I request that no coercive action should be taken against me because I am.
No. What is coercive action?
My lords, the police has started calling me to join
and I apprehend that they may arrest or they may
498, who is arresting nowadays? Police are very busy in other cases.
My lords
Who is
may
bothered
kindly,
about your-
my lords may kindly consider putting a line on
do
that.
any better crime.
My lords may kindly consider, my lords, that person has undergone a heart surgery.
Anish Kumar guidelines will be followed.
41 notice, 498.
My lords may observe something, lordships, in vacation time, my lords, it will be difficult. Lordships, a 65-year-old man, he has a pacemaker,
Yes.
recent, my lords.
He is the uncle. 62 or 70 year, whatever.
65, my lords, not 62, 65.
Your Lordship may observe that the police will observe the Anish Kumar guidelines. Then automatically 41 A will be.
My lords, I am prepared to join investigation, my lords. I don't have an issue. My lords.
The counsel for the petitioner submits that he would be cooperating with the investigation. And the police, if any course is taken, in May, the police shall follow the guidelines provided in the
Anish Kumar state of Bihar. So I'll give the citation.
Anish Kumar, judgment. Anish Kumar, which for the police issue notice under section 41A, the petitioner shall appear before the police and cooperate with the investigation. Yes.
Grateful, lordships, deeply grateful, lords.
Anish Kumar, he has to follow Anish Kumar guidelines. Yes.
Grateful, lords.
42. 42.
As the citation.
Citation there, Anish Kumar citation.
2014 8 SEC 273.
Are you writing?
2014 8 SEC 273. Anish Kumar versus State of Bihar.
State of Bihar. Okay.
The lordships view has been affirmed by the apex court that 205 application in ED cases. And that same now judgment has come.
Let him move fresh up. Yes. That has been rejected. Yes. Petitioner
205 has been rejected, my lord.
Same order.
Yes. He must appear, give a bond and.
Yes.
205 Para 23.
23, my lord.
In my case.
No, para, I am telling para 23. Para 23 didn't say everything. Para 23. And you move application and that will be decided in the light of para 23.
He will to appear, give a bond and.
I'm just removing an application para 23. Sir.
Yes.
That
petition is agreed by the order dated 25/4/2024 passed by the special judge Sibo Sankar Mishra in criminal miss case bracket TMLA number 84 of 2020. Whereby the application under section 205 CRPC has been rejected. The law regarding the maintainability of application under section 205 CRPC in a PMLA case has been decided by the Honorable Supreme Court in the recent judgment of 13 law. In view of the law settled by the Supreme Court, the impugn order dated 25/4/2024 passed by so is passed and petitioner is granted liberty to move a fresh application. If such application is moved, the same shall be considered in the light of the para 23. In the light of para 23 of Third Sem Lang Supra. Allowed. Yes.
Your lordship may fix up a date to appear with the.
Petitioner shall appear before the trial court on or before 30th of June. And 30th June 2024 and move appropriate application in accordance with the law. Yes. 30th June, within 30th June, on or before 30th June, move, appear and move application. Yes. Disposable. 43. Mr. Agrawal's name also like that.
302 case.
Yes, Father.
Yes.
Because anticipatory bail has been rejected. This is an unfortunate incident. There was an altercation between a customer and the grocery shop owner. No physical assault, though they say that he has been pushed. The PM report disputes. Otherwise, it is culpable homicide, not amounting to murder. He dies out of a cardiac arrest. Now, no physical bruises on the body is totally clean. Actually, what happened, Malots, as he was describing, Malots, that they were across the table and means this table which is in front of the shop. So there was like some discount or something, 30, 40 rupees discount. So they said, you take back the goods. He started yelling. So he had a weak heart before that and he collapsed and he died as a result there. So this is the thing, Malak, 302 has been, post-mortem report also has been annexed. There is no touch to the body.
In the post-mortem report, where does it say that heart?
Annexed 2 months.
No,
Your Lordship will see page 21.
Cause of death
21.
On dissection.
Page 22.
Yes.
The above mentioned findings and the internal effects are antemortem in nature. Death is due to cerebral vascular accident and dilated cardiomyopathy, which is Malak's the heart was extended. So Malak's, it is an
but still investigation is on.
Investigation is on Malak's, but Malak's 302 at best it can amount to Malak's your Lordship will see the.
But then page 21 shows there was also a cerebral hemorrhage.
Cerebral hemorrhage because he fell down.
Coupled with
collapse.
No, it's all right, but the investigation is still on. How do you know that it will be 302?
Malaks, they've.
Why are you preempting things?
They have already
filed the charge sheet.
Initiated the. No, they haven't filed the charge sheet.
They may file a charge sheet under a lesser offense.
The FIR is registered under 302.
FIR may be registered. Maybe registered. It's still investigation. If premature, I simply adjourn. Let us see what provision they are filing in. If they are filing in the 302, then we will examine.
Yes.
If they file a lesser one, why should I examine?
Then
Unnecessary. No, it is a premature. Simply I am adjourn. Issue notice and issue notice.
Notice and.
Let us see. They may file a for lesser offense.
Yes. Subject to what?
No, but anticipatory bail is rejected. Nah, that's the whole difficulty.
40 rupees, this has happened.
That's the whole difficulty. Once you burn your finger by getting in order, how can I sideline that order? Otherwise, I would have done it.
Yes.
Whatever I do.
I know.
You go to, but I issue notice, you know, where to go now. Where to go now. Yes. 45.
Another matter, 113, I don't think elections will be able to take up today.
Yes, yes.
Are you election sitting here in the meeting?
On 23rd, I am sitting.
Will your lordship take up these matters or some other matter?
If it's not very pressing urgency, then after vacation only. Do you have a pressing urgency?
It's quashing.
Quashing, then after immediately.
Reopening makes
Reopening, yes. In that matter, the earlier matter, issue notice and call for CD.
May I pray? Because your lordships had fixed a time. Any date after reopening at 2 o'clock?
2 o'clock.
At 2 o'clock?
No, I am thinking of the other matter where is that item?
113. 113.
No. 43, na? What I just record your statement so that you can get the benefit by challenging that order. I'll just record your statement. The petitioner has in the present petitioner is seeking quashing of FIR registered against him under section so. Mr. Submits that the deceased was suffering heart ailment due to unfortunate incident. Due to unfortunate incident on the on such and such day, Kevere incident. incident on such such day. He fell down. He fell down. And
collapsed.
Fell down and collapsed. He said things can be.
And we took him to the hospital.
Huh?
We took him to the hospital.
Collapsed. Immediately thereafter, the accused persons themselves have taken the deceased to the hospital. This aspect could be drawn the corroboration from the medical, the postmortem report, which is placed on record. Investigation is still going on. Therefore, at this stage, no order could be passed except issuance of notice to the opposite to the state. Mr. Behra then comes for the state to accept notice and seeks time to produce the CD before this court. So they use that portion.
Yes, sir. We will try our best. And 113 minutes.
Simply
at
urgent
2
to
o'clock.
2 o'clock. Yes.
Obliged.
Next.
45.
This 302 case already trial has started.
Well started. Yes, sir. You are still stuck in cognizance order.
No, Mercy, that the order was applied by me, but I am not getting.
You are seeking quashing of the entire proceeding.
Yes, ma'am.
On what ground?
That I am entitled in this case, my lord, due to the statement given by the informant that this is father. While on the way of the hospital, he was trying to catch before the.
But now charge has been framed and everything is done. Now quashing means what?
I am.
This is a 302 case.
But that is entire incident happened to the political mismanagement. That the deceased is the ex-Samiti member and the prime accused in this case, the Ajit, is the present Samiti member. The political image, due to political image, the deceased service was there. And due to the rivalry, entire 16 to 17 people are entitled in this case. And I am the brother-in-law and as well as the petitioner who is the husband of the present Sarpanch. That in order to that basis, that I am also implicated in this case. That entire case sustaining due to the lordship, the statement given by the informant. 3 numbers of eyewitnesses in the airways. All are not supporting the prosecution in the.
Very good. You will be a good. Nobody has supported you. Prosecution.
No. Entire the 3 numbers of eyewitnesses. Those are claimed to be seen the occurrence at the time of occurrence. They are not supporting the prosecution case. They are also stated before the.
Where?
What is that page number?
Where they have stated?
In exemption sheet files. I'll see page number 158 to 164. Under annexed 4 months.
But how can I quash the criminal prosecution if the evidence is going on?
What is the implication?
How many witnesses total?
Was 31 witnesses. 9 have been examined.
9 have been examined. You are on bail.
No. The antecedent is fine. 2 times fine. Antecedent is jail.
By showing all these things, why are you not getting out of the jail? No, there is no material according to you.
Yes, ma'am.
If you think that you have a very good case for quashing in 302, don't you think that you have a good case for bail also?
This is the fate of the client. That discretion, I am not upon that. Every evidence is not upon that discretion.
Evidence is recorded and the 9 witnesses have already been examined.
Yes, ma'am.
What is the worth of that? Those evidences has to be gone into by the trial court only. I can't go into all this.
The post occurrence witness and 3 eyewitness. The post occurrence witness.
Everything all right, but how can I curtain the trial?
No, I'm not saying that.
Then what are you saying?
But in the meantime, NPW is against me. But I am applied for the NPW order, but that order is not reaching me.
When you give me the NPW, I'll stay and go and appear.
Only 2 days, my lordship, possibly it's fixed to the 23rd, my lordship.
You show me the NPW and I'll say that and I give you a date, go and appear and contest it. Very simple. Unnecessary. Why should you? You tell me the date of NBW. I will pass the order right.
I don't know the date. That is the difficult. Because the learn.
Do you have the?
Yes, I'm applying for the certificate.
Give me the date. I'll record your statement and I'll tell that it will not be executed.
Already counsel in the trial court that he stated me that he applied for the equitable order and that order is not with me now. And I'm just get the document.
And Maharaj, there is PW3, your lordship will see a dying
No,
declaration.
don't go. Who can interfere in this case? The only thing is he has an NBW.
NBW.
Your
And
lordship
say
may say,
the NBW, let him go and apply and
Your lordship,
contest
please.
his-
Your lordship,
that's- But he is not able to tell me the date also. What can I say?
If my lordship possible, fix the matter to 23rd marriage.
Chalo, 23rd, 23rd. Okay. But you come with that order at least. If not certificate copy, at least the photocopy.
My lordship,
I will stay that NBW and go and appear and contest evidence. Yes.
46.
Yes.
May I please, Your Lordship? Your Lordship, the entire is law against the present petitioner in a very excessive manner. Here the informant alleged that due to previous enmity and some love relations, this person targeted his cousin brother, and attacked. Here it is written, ସକାଳେ ମୋ ବଡ଼ ଭାଇ ଲିଙ୍କନ ପଳିଆର ସିଂ ପିତା ସ୍ୱୟଂସର ମଦନପୁର କଲେଜକୁ ଫେରୁଥିଲା ବେଳେ କିଛି ଜଣ ଦୁର୍ବୃତ୍ତ କିଛି ଜଣ ଦୁର୍ବୃତ୍ତ ମଦନପୁର ହାଇସ୍କୁଲ ସାମ୍ନାରେ ଆଗରେ ଖଣ୍ଡାରେ ଆକ୍ରମଣ କରିଥିଲେ। ଏହାଦ୍ୱାରା ସେ ଗୁରୁତର ଅବସ୍ଥାରେ ଏମ୍ସ ହସ୍ପିଟାଲରେ ଜୀବନ ସହ ସଂଗ୍ରାମ କରୁଛନ୍ତି। ଏସବୁ ଘଟଣା ଜ୍ଞାନ ରଞ୍ଜନ ମାନଚିତ ଅପରେଟିଭ ପିଟିସନର ୟୁର ଲର୍ଡସିପ ଏବଂ ତାଙ୍କ ସହଯୋଗୀମାନେ ଘଟେଇ ଫେରାର ହେଇଯାଉଛନ୍ତି। There is no there no they don't know who the miscreants are, but they are apprehending due to the previous enmity. They might have committed these things. This is the case here also. And if you also kindly look at the annexure 2, I have written and the more specifically page number 18.
What is the stage?
Charge sheet has not been filed. Investigation is on.
Well, my lord, but the reason
And
is that,
at the investigation stage only, you have so many defense.
yes, Lord, because my lord, at that time I was not in Odisha only. I have already filed the
Go and give all this paper to the police.
Yes, it is already on record, Your Lordship, because
Go, they will consider.
yes,
They will consider.
the anticipatory value which get filed by the time it got rejected by the Honorable Court. So I
I
am
know.
not paying for any other.
I know, that's the problem you are here.
Yes.
I know.
This is the,
And the police will verify the alibi.
The plea of alibi and something. That will be responsible for the petitioner seeks to withdraw this petition. Petitioner is seeking quashing of the FIR number 2 so from FIR number 2. Okay, understood. Investigation is still going. We signaled this up before because on the date of incident, according to him, he was not even present in the place of occurrence. Due to past enmity, he has been implicated in this case. He is relying upon various documents placed before this court along with the present petition. I am not inclined to interfere in this matter at this stage since investigation is going on. However, liberty is granted to the petitioner to place all these documents before the investigating officer. If such documents are filed, the worthiness of this document and relevancy of those documents shall be considered by the IU. With this observation,
one more thing may I add to your also that this order, rejection order, will not come into waste. By the time the charge sheet is prepared, they will not be influenced by this.
I am not rejected. I am not rejected. I am only simply saying that whatever document you filed, give it to police. Police will see what is the relevancy of it. That's what I'll say. Yes. 47. This food,
May I please? Proceeding on the ground of compromise. The charge sheet submitted on the section 498, 6 of finance.
Where are they? 498, eh?
498 3060.
306.
06, my lord, as per initially, my lord, UB case was registered. In the UD case, my lord, there is no such allegation given by the complainant. Thereafter, my lord, come to FIR, my lord. In the FIR, my lord.
No, FIR was 302.
Yes, ma'am. Thereafter, it was investigated and during the investigation.
306 was filed.
306 and 498. And in the past report, my lord, he has not made any allegation with regards to demand of dowry or anything, my lord.
Forget about dowry. 306.
306
Get over 306.
also not there in the first initial. I have annexed that report, ma'am. Annexure 1, page 17.
Mr. Maharaj, what are the evidence?
Page 17, annexure 1.
306 evidence.
306 evidence is my SPC hanging. And very
Poisoning.
no, ma'am. Hanging.
Throttling.
CC committed.
No, what are the circumstances? In the closed door or who were there? He is the husband, the only one accused.
Yes, ma'am. At the time of occurrence, my lord.
And who is Vrindavan Sahu, father of the deceased?
Yes, ma'am. Yes, no. By the time of the occurrence, my lord, husband was not there. He was shifted to medical. After hearing the news, my lord, he became senseless, man.
Who?
The husband, man. He was.
Where is that?
Page 17, man. Last paragraph.
This is an affidavit on behalf of OP number 2 minutes. The thing is that minutes, the first reference lost after the incident was happened. And after 13, more than 15 days after, the IIC forced us to register the FIR, or you will put behind the bar, or you will put us behind the bar. That's why we have filed the second FIR.
Have you said all these things?
Yes, my lord. I have already written on this.
Which paragraph?
Under paragraph. Minutes. But para 5. Para 5 from the bottom. 9 line. From the bottom. Thereafter, knowing after the truth of the incident and about the innocence of my son-in-law, named is Sibo Sankar, that is the present petitioner and his family members. I have tried to convince the investigating officer.
Hey, what is this, Mr. Maharaj?
One thing I thought from the page 17. My last say
all these are 161 statements. But what the complainant says in the affidavit in this court says that it is the investigating officer who forced him to write this FIR. I have very good relationship with my son-in-law and their family. I would not have filed this affidavit if FIR if the police would not have insisted upon me. In the face of this, what is this? Who is this?
Complainant statement is your lordship kindly found. Page 17.
As it is there in distress, the family, and the IOs are creating problem.
But in the present scenario, I don't want to further.
Well, it's all right, not to aggravate it. Right on. At the instance of opposite party number 2, FIR number so and so came to the register against the petitioner. After investigation, charge sheet has been filed on. Charge sheet is filed on 31/5/2022 for alleged offence under section 498A 306 IPC. 306 IPC. Before the trial in this present case, and the parties at this stage, the parties have settled their dispute. The petitioner and opposite party number 2 are present in the court, being represented by their counsel and okay. The opposite party number 2 has filed an affidavit before this court, inter alia stating as under para 4 and 5. The perusal of the affidavit, perusal of the content of the affidavit reveals that it is the investigating agency officer who has insisted the opposite party number 2 to file an affidavit, lodge the FIR, and on on the insistence of the police, the FIR was lodged against the petitioner for offence under section 498A and 302 IPC. However, after investigation, charge sheet is filed under section 498A and 306 IPC. The allegation made by the opposite party number 2 against the investigating officer is serious in nature. By way of the affidavit before this court, affidavit dated today, date na? Affidavit dated 21/5/2024, the opposite party has made allegation against the investigating officer. I don't want to precipitate the situation by passing any order against the investigating officer. However, suffice to say that his conduct is deplorable. Having said that, I'm inclined to allow the present petition and quash the entire criminal prosecution against the petitioner in view of the fact that they have settled their dispute, and in view of the affidavit filed by opposite party number 2. Mr. Maharaja appears for the state and submits that what has transpired during the investigation is a matter to be verified. However,
after completion of investigation, the affidavit has been filed.
A matter to be verified, and after investigation, charge sheet has been filed. Therefore, he submits that. He submits that since the parties have settled their dispute and they are appearing before this court and filed affidavit regarding the settlement, no further order is required, and this court can give indulgence in view of the law laid down by the Supreme Court in Quashing and PC Joshi. Taking into consideration the affidavit filed by the opposite party number 2 and law laid down by the Supreme Court in Quashing Supra and PC Joshi Supra. PC Joshi Supra. I'm inclined to the present petition deserves merit, and subjecting to the petitioner to trial will be a futile exercise. Therefore, accordingly, the FIR and consequential proceeding arising therefrom are quashed. Yes.
48.
48. এটা 48 টা আসু
কোন এটা?
It is
48. First time coming.
First time কইছে পিটিশন এবার থিলে থেকে তো করুଥିଲେ
Non appears in the interest of justice at them. ঠিক আছে।
জানি পাইলেন হ্যাঁ 48 से जो opposite party opposite party जितंग तक 48 টা as it appears it covered by your lordship judgment, but I have to go through
Surya Kanjana
48.
They were so excited.
Yeah, কিন্তু I have to go through. আসো ডে 23 তারিখ আসো I'll verify
by vacation you don't
after
know how many cases after pata chala vacation na rahe ho, then you keep on sitting till 7 o'clock. Spoil the vacation.
After
court of some courts are here.
All the courts have gone except this court. Yes.
I was just telling my friend at 482 438
That would have been better. Instead of waiting time, keep 438 minutes now. Because 438 they are not getting there, for 482 is being filed. Yes.
In the vacation, your lordship will hear on 438. 438.
God make it clear. Which one? Sorry.
97.
97, again. Why should, yes, no problem. This can be taken after vacation? Yes, after vacation. Yes. And what, any urgent matters?
49.
49.
Yes. 49. Criminal appeal. That's how is sentence.
3 years maximum.
3 years 5,000.
In one offense 2 years and in another offense 3 years.
Bail. Fine stay, not conviction.
And free copy.
Yes. Bail matters.
49
49 हो गया ना 49 appeal है ना
sentence.
हाँ appeal admitted, sentence suspended and bail. Yes.
Bail matters.
All bail matters.
85.
25. How many bail matters are there?
Four.
Four bill matters. Four matters.
Yes. We can take it, these 4 matters on 23rd. 23rd leisurely, no problem. 23rd.
Your Lordship had practically heard it regarding that interpretation of 437(1), that when a life conviction is there, can the magistrate grant bail? That is the point. Let it come after vacation.
Today is not more.
No, I'll just point out the provision of law, nothing else. And I'll just place one judgment.
Yes. It needs little hearing.
Malad, can it be on 19th if I don't disturb?
Lordship, I have mentioned one matter. In fact, my learned friend is here. This is
one after another. I'm
100.
here for another half an hour.
Lordship. I have already told my learned friend.
Yes. 1 minute. What do you want? 23rd may not be possible. See, 23rd is a vacation. Nobody will cut you off. What is the urgency?
No urgency. What I'm saying, your Lordship has charged completely. The other side is to file the
The other side will not come on 23rd. Why? What is the use?
So let
it be immediately after vacation. देखिए 114. हाँ देखिए date दो हाँ.
That item number 19th, your Lordship.
Item post matter 19th.
My learned friend said 19th. I connect 20th matter. I pray 20th matter.
20th.
20th. I have no objection.
My lord.
That bail matters, your Lordship, keep it to 23rd.
All bail matters 23rd.
91, your Lordship.
Bail matters we have CRMC and appeal.
No, tied up matter.
Tied up.
These are tied up matter.
Let's say 91. Let's say 91 is a small.
Item number 106, Lordship. Lordship, I have moved one application and yesterday I moved one withdraw memo. The whole point is this matter needs to be heard because, and one more thing, my lord. There were 4 accused in the
Every matter has to be heard.
Lordship,
What do you want today?
Lordship, can this matter be heard on 23rd? There is urgency in this because every 15 days I have to appear before executive magistrate. Absolutely. Not in the affair, not.
Which item?
106, Lordship.
106? 1 minute.
And in fact, I have moved an application also.
1 minute. Don't do.
And the record will be.
1 minute. What is 106?
Withdrawal memo filed.
Withdrawal memo filed.
Lordship, I have just filed a memo. I don't want to press it because, Lordship, whole point, and I mentioned it yesterday.
What is your case here?
Lordship, my case is offenses.
You are seeking quashing of FIR.
Yes, Lordship.
Application you have moved for withdrawal.
I moved an application for preponement because this matter was listed on 5th of May, 8th of May. I missed the matter because I was there virtually because my name was repeatedly mentioned in item number 40 and item number 63.
Now it is urgent to
29th of August, and I have moved an application also, preponement application for that. So, my lord, kindly hear this one because in the FIR 4 names were there, 2 names were exonerated, only 2 senior citizens were there. This 2 petitioners are senior citizen, and the complainant is my younger brother. And absolute, either memo I have given, just a memo. I don't know.
He has given.
And I have moved an application for
when the matter was taken up, he was not there. Matter is urgent. Then he gave a memo to withdraw. Now he says that urgent. I don't know what.
Because I don't want it. Because I wanted to file it tomorrow so that my lord may, and I could have mentioned it on 23rd or 28th for a hearing, my lordship.
I just want to know what do you want?
I just want this matter to be heard on 23rd.
No,
okay, please.
Next.
28th.
That also not. Next, what is the urgency?
Extreme urgency is for no reason. In fact, Lordship can go, record is there. My learned friend is holding the record also now. There is no criminal ingredient.
That is the urgency.
Lordship, urgency is every 14 days I am being heard, I am being called to appear before executive magistrate. Urgency is
Where is the condition?
Condition. No, I have annexed that one, Lordship. I have annexed that one. They have in fact, the IO has moved an 107 proceeding before the executive magistrate. That is there, Lordship.
You are accused in which case? What?
106, Lordship. 106.
94, 34 and 506 you are accused.
Yes.
Where is the question of 107 now?
Well initiated. I have annexed that one.
Then you have to go
Absolutely civil matter, Lordship.
Between two brothers.
Two brothers.
Why are you so excited? You have to go and appear before executive magistrate. That is what your problem.
Yes, Lordship.
That's what you are
Yes.
saying, na? Vacation, you excuse him vacation, I will say that. One minute. Let us solve his problem.
My lord, I am just submitting the, my lord has spread me for 4 o'clock.
Matter has already been adjourned. 1 minute. Matter has, 1 minute, sir. Matter has already been adjourned. 106, 106. When the matter was taken up on 8/5/2024, due to absence of the counsel for the petitioner, matter was adjourned to 29/8/2020. Learned counsel for the petitioner moved an application seeking preponement of the date of hearing. In view of the urgency involved in the matter, he submits that the petitioners are senior citizen and absolutely there is no case against them. However, due to the initiation of the proceeding by the prosecution under section 107 CRPC, he need to appear before the magistrate on every
15 days.
Every 15 days. Therefore, he seeks indulgence of this court till the matter is taken up on the by next date of hearing. The personal appearance of the petitioner before which
executive magistrate ADCP Cuttack.
ADCP court shall be exempted.
Lordship, what specifically may I mention that criminal miscase number 641 of 2024.
641.
Criminal miscase number
pending before
ADCP Cuttack.
Personal appearance of the petitioner shall be exempted before CDP so and so.
Before further. Till further.
May I be pardoned? May I be pardoned?
Grade 91 is small matter.
So take away your withdrawal.
Yeah. Lordship, one more thing. And now this matter will be heard on 1st of July before this JMFC 4. That is also okay.
102. 91, your lordship.
My lord, may I bother my lord? I am busy, my lord.
1/5/2024.
1 minute.
105. My lord, directed to the appearing before the court below on or before 30th May 2024, and also directed to deposit 2,000 rupees. But my lord, the allegations are 364. 364 trial by sessions. But if my lord, I appear before the law and court below, that is JMFC.
What do you want?
Arrest for them, my lord. The first or second or my lord, more release.
Hey, आपलोग NBW
नहीं, sorry, abscond NBW होता है my lord.
Then you won't appear before.
My lord, the
matter has already been committed.
My lord, yes, my lord, committed.
Where is that application?
105.
105. Right on. Learned counsel for the petitioner has moved application seeking modification of the order dated 1/5/2024. He submits that by the time the state order was passed, the matter has already been committed to which court?
Before the additional district session judge Oregon.
Additional session judge?
Additional district session judge Oregon.
Therefore, in view thereof, he seeks modification of the order dated 1/5/2024. Accordingly, the modification application is allowed. Petitioner is directed to appear before the assistant session judge, additional session judge Oregon on or before 30th of June, so and so, and move appropriate application under law. and the rest of the part, in that term, the modification application is allowed, and the rest part of the order remains. Yes.
Parity ko third parity ko third.
No,
91, you will see
all the-
changing of nomenclature only, 91.
91 changing of nomenclature application.
Yes, I application file years, changing of
The
nomenclature.
application moved by the petitioner for changing of the nomenclature is allowed. The registry is directed to renumber the petition and list before the public bench. Yes, next.
Beg pardon, my lord. 107, it is a criminal appeal against conviction. My lord, here the IA number 1280 of 2024 filed for early hearing. Here, my lord, the paper book not prepared. The petitioner want to deposit the cost for preparation of paper book.
Office will prepare the paperwork,
Office-
they will deposit the cost.
I will,
The
Registry.
107. Right on. Mr. Sahul and Controller petition submits that he submits that the application is moved for early hearing of the appeal. His client would deposit the cost of preparation of paperwork. If the cost is deposited, the paperwork shall be prepared and supply the copy. Yes.
Grateful, my lord.
Item 19. It's not so important, but may color this matter 19 but 20th because 209.
All dates you can take. Yes, Mr. Padi, what was the problem?
Yes, till that they are not able to pass order because I heard that non-official he is busy with the EVM work. So let's say pass it 50,000 to studies fine, why not? I am accepting.
Just now I have taken instruction from the IAC, my lord.
Yeah.
She stated me that order already been passed, my lord. What is the order? She cannot say what is the order, my lord.
Order is already.
SDM is not present, available in the office.
No, he talked.
Just now before 2 minutes, my friend has intimated me.
He has given taken instruction from the IIT.
Completely, I don't dispute my friends because his internal communication with the IAC. But my advocates are very much present in the SDM court. None is IAC is not there, the court is not there. Only 2 clerks is sitting in the office.
What is this? I don't know.
What I'm saying, if my lord will pass with 50,000 what my lord observe, then no prejudice to anybody.
Giving respect to the honorable court, my lord, they have passed order. What is the what? See order na kahi pareng kone chhe.
Mr. Raghunath, land counsel for the petition.
Take instructions from the IAC.
Opposite party submits that the executive magistrate has already passed order in pursuit to the direction of this court. However, the outcome is not known to him. Mr. P.K. Pari appearing for the petitioner controverts this fact. Be that as it may, leaves the matter on 23rd as a first item. As a first item. If the order is not passed, then I'll take serious serious view on this executive magistrate. What is this? The court says that 101, 102.
They are not such audacity, my lord, not to comply with it. He has giving due respect to the order of this honorable court.
You just convey. If he has not passed the order, then
he has already passed, my lord.
Irrespective of whatever rejection, everything, and call him to appear here.
Already passed the order.
See, for 110, we can't waste time like this.
My lord, he has already passed the order.
Anyway.
My lord, 119, my lord, 119, similar to yesterday item 21, my lord. That has been disposed of. My lord.
Any urgency, Mr.
Maybe pardon to mention, my lords. CRL MC number 1376, I had mentioned it 2 days earlier, my lords. The stay order that was passed in the court wasn't reflected in the order, my lords. My lords had directed the learned court master to verify. He had verified, and on instructions I'm stating, he has sent a requisition for correction of the order that has not been done. I have filed a IF to that effect, my lords. May kindly be taken up 23rd, my lords. Prejudice will be caused. Stay order that was given in the court has not been reflected.
See, Mr. Jyoti Prakash is saying that he has passed on the instruction to the registry. It will be done. If it doesn't happen on 23rd, you mentioned. I'll take up on the same day. I'll get it done.
My lords, I'm grateful. I'm grateful. I'm so grateful.
Yes, Mr. Ashwini Kumar.
As far as the item 122 is concerned, it is a covered matter. Last time also I had told. The thing is that I want this matter to be disposed of. It is because it's totally a covered matter. The second thing, whatever may be the result of this case, because state is will go to Supreme Court because they have challenged the covered matter, covered order. honestly speaking, I want this matter to be disposed of. That's why
Then
I'm asking.
if you know
It
that
may be taken up
you
125.
are covered by a particular judgment and they have already challenged that order
Exactly.
before Supreme Court, wait till outcome.
Exactly.
If that
No,
is
it
upheld,
will be delayed. I
you
will
are
be
covered.
prejudiced.
If it is not upheld,
No. My point is, my lord, if in the event if it is rejected by this honorable court, I will have the privilege to go to the Supreme Court. See
why do you burden your client to go to Supreme Court? Wait, don't burden your
because
client
all
to
the
go to-
orders, all the connected matters it is pending before the Supreme Court. That is the
let us all
problem
of,
here.
let us all of us wait for the judgment of Supreme Court. If my
It
order
will be
is
delayed. It will take because my lord, this order for which I have come to this court, it has been passed after 5 years. This matter was tagged with another
you are
matter.
covered by
which is
which
covered.
judgment?
That one.
Which judgment is that?
This
Covered by?
covered by this. I just quoting this. This was the judgment is in my case.
So it is covered or not? You are saying covered. He say no. It needs hearing.
What he says, this matter. Beg your pardon?
Yeah.